Good morning. Thank you for on behalf of the judges, BFR, Limited, and B5.
Good morning, Ms. Garcia. Good morning, Ms. Burns. Everybody unmute. Anyone, any attorneys on Zoom that need to enter an appearance? No? Okay. All right, so we had begun taking evidence on Mr. Sweetapple's motion, and we bifurcated Ms. Garcia's motion. Then we ran out of time. We tried to call up the case for, I think, Hurricane Milton, tried to call up a case for Hurricane Helene, and now we're here for the conclusion of the presentation of evidence on the two matters. I think when we broke, we were in the middle of Mr. Sweetapple's direct examination. So Mr. Sweetapple, do you have any additional witnesses or evidence that you'd like to present?
Yes, please. I showed Ms. Garcia a number of documents, most of which are for judicial notice, because it's my position this case is ultimately a matter of law. I did put in reports from the examining committee, but the court was concerned about them being hearsay. And even though I believe this is a collateral estoppel argument and that Judge Burton clearly ruled that he relied on those, the court indicated, well, the date could be hearsay. So I indicated that I call Dr. Bloom and Dr. Cheshire. They're going to be 15 minutes each, half an hour each, but they're not available until 1:30 and 2.
Okay.
So after I put in these exhibits, which I believe Ms. Garcia has no objection to, I won't have any witnesses to call until then, and she can proceed.
Okay.
All right. So if I may, I'm going to move in. And what exhibit number are we on? Thank you. And I can hand these to your clerk for the court.
Just see them. I would show them to Ms. Garcia first.
Yes. So I'm going to just hand it to clerk to Mark.
Let me see if Ms. Garcia has an objection. So that's
for identification.
Sure. So plaintiff's exhibit number 5. What is that document?
This is an email from Ms. Garcia to Mr. Raymond, and a copy of a settlement agreement that she transmitted to him prior to the one that was executed in this case.
Ms. Garcia, do you have any legal objection to plaintiff's exhibit number 5?
I have the objection that he's redacted the first page, and I guess for completeness, I have my chain of emails I would move in, I guess without objection.
Cool.
But also, he's got an attachment here, but I don't see an attachment referred to in emails. Says it.
Yeah, so I can tell the court that this was transmitted to me by my client, and I responded to my client. So this redaction is all communication with my client. If she wants to put that in for the court to review on camera, I have no problem, but I'm not waiving the privilege by adding her email to Mr. Raymond, and the document sent to Mr. Raymond that was forwarded to me by my client, and then I responded to my client. That's the only redaction, and you'll see that if you see her. I don't think she does that.
Do you have an objection to the exhibit?
No, Your Honor.
Okay. Then I will receive it into evidence without objection as plaintiff's exhibit 5.
Under number 6 is an order from the bankruptcy court dated April 14, 2023, which is 3 days before the filing of the petition. I'm asking the court to take judicial notice of that. Of the sanction finding, part of my motion for sanctions.
Is there any legal objection to exhibit number 6?
Your Honor, he did not file a proper timely motion for judicial notice, so I object on that basis.
How are you procedurally prejudiced by his introduction of this?
Procedurally, Your Honor?
Yes, ma'am.
I mean, you can say I've seen it before, Your Honor, so.
She was a party. She's filed this proceeding, Your Honor, and was the
I believe this was attached to the motion originally, so I hear that your objection that you weren't given proper notice, and I'm asking procedurally, how are you prejudiced by the lack of proper notice?
First of all, I don't think it's on his original exhibit list, and you limited us to our original exhibit list. Unless there was documents discovered that I was produced to him during a deposition. So I produced many documents to him during a deposition that I intend to use. Secondly, had I known he was going to be moving this in today, I would have called the attorney who drafted this order, because...
Your Honor, this is Exhibit J to our motion to strike that you're hearing. This has been...
This is an order signed by a judge, is it not?
Yeah, this was signed by the bankruptcy court.
Sweetapple, Ms. Garcia is
Yes,
articulating to me her procedural prejudice, so.
Yeah, it is signed by the judge, Your Honor, and it will be taken up in that court, fraud. So use it how he wants today, and we'll deal with it there.
All right, then I'm going to receive Exhibit 6 over objection as plaintiff's exhibit number 6.
Number 7, Your Honor, is the request for judicial notice. I filed in this case file, and Ms. Garcia was e-served with this, I believe, April 18th, 2023. Mentioned my case, but
That's exhibit number 7.
Do you have a copy, sir?
Ms. Garcia, what is your position with respect to plaintiff's exhibit number 7?
No objection.
All right, I will receive this into evidence as plaintiff's exhibit number 7.
Exhibit 8, Your Honor, is the objection to the examining committee filed by Amber Patwell as counsel for Patricia Sahm in case number 50-2023. Some of these that have mental health may have been filed under seal, so we'll have to be aware of that. In the underlying case,
What's your position, Ms. Garcia, with, I believe, plaintiff's exhibit number 8?
No objection.
It'll be received into evidence without objection as plaintiff's exhibit number 8.
And then, Your Honor, I have Ms. Garcia's appearance in the underlying case where Judge Burton issued his order, which I'm asking for.
Ms. Garcia, what's your position with respect to plaintiff's exhibit number 9?
Same objection to the record, Your Honor, that he didn't properly file for the judicial notice.
I thought that at the
objection.
Okay, so there's no objection. If there's no objection, then I'll receive it into evidence without objection. But I thought that initially there was a request for the court to take judicial notice of the entire mental health guardianship court file.
I believe so, Your Honor.
First hearing in August. So I don't find that you weren't given proper notice, but there's no objection. So I'll receive it into evidence as 9.
And Your Honor, I did put in Judge Burton's order.
9, that was 9. 8 was the lack of it was the objection to the examining committee report.
Okay, that's 8.
Yes, ma'am.
Your Honor, I already put in Judge Burton's order determining incapacity, but I did not put in his order appointing limited guardian of the person and property entered contemporaneously. So I'm moving with the court to take judicial notice of that order as well.
What's the date of that order?
It is June, I think 22nd. June 27th, 2023.
Ms. Garcia, what's your position with respect to?
No objection.
I will receive it into evidence without objection as plaintiff's exhibit number 10.
And lastly, Your Honor, is an order granting final injunction for protection against exploitation of a vulnerable adult. by Judge Burton. And it is dated September 22, 2023, Your Honor.
All right. Ms. Garcia?
Objection on this one to relevance.
What is the relevance, Mr. Sweetapple?
Findings in this order that Judge Burton made regarding, and I can read to the court, the respondent is the younger sister, Patricia Sahm Jr. This is on page 4 of 14. The respondent further testified that in March of 2023, a female notary arrived at the residence then occupied by a respondent and the vulnerable adult. Although the respondent suspected that the Bernstein family, with whom the vulnerable adult is currently litigating against, or Kevin Hall, an attorney involved in that litigation, sent the notary to the residence, the respondent claims that she took no action while the notary notarized a vulnerable adult's signature on documents that revoked the power of attorney in favor of the vulnerable adult's then acting agent and trustee, JOANNA. So this relates specifically to conduct that occurred at the time of the guardianship that this court is reviewing. And even though there is a legal argument being made as to why the court, as on a matter of collateral estoppel, has to find incapacity, I'm also making a record factually through the experts and the testimony to show the improper conduct, because I have asked for sanctions against Ms. Garcia, including for her client's conduct at her direction.
All right. Anything further, Ms. Garcia?
Again, objection to relevance. Time frame 9/22/23 after the fact. This is a hearing that was not concluded. I'll testify, I guess, to fraud being perpetrated today, and I'll deal with any other courts.
What? I'm sorry. You handed me a 14-page document, I think. Is this a permanent final injunction, or is it time limited?
Pardon, Your Honor?
Is this a permanent final injunction? I apologize.
This is an order that has not been appealed or vacated of Judge Burton.
No, but some injunctions are, say, for a period of 6 months or 8 months. Is this?
It was an agreed final injunction that the court made no findings. They put it in the order anyway. I have the transcript. I'll deal with it with the other judge now that they're using it here in front of you.
All right. I'm going to receive it into evidence over objection. Subject, of course, to Ms. Garcia explaining why it's not relevant to the court's consideration, ultimate consideration. For the purposes of the hearing, I will admit it into evidence, and you can tell me why I shouldn't give it any weight.
But you're going to take judicial notice of it?
Yes, I'm admitting it into evidence over their objection. But she's certainly free to tell me why it should not bear in my decision making.
And other than calling Dr. Bloom and Dr. Cheshire, I don't anticipate any other witness unless there's some rebuttal necessary.
And you said Dr. Bloom and Dr. Cheshire would testify at
1:30 and 2, I have them stand by on Zoom.
Okay.
I tried to get them this morning and I couldn't.
That's okay. All right. Ms. Garcia, with respect to your motions, do you have any witnesses or evidence that you'd like to admit?
Evidence? Yes, Your Honor.
Or witnesses?
I'm sorry?
Or witnesses, either testimony or evidence that you'd like to submit?
Yes, Your Honor, but I have an issue with me having to try my case in the middle of his case. His witnesses should be here timely. It was set for 11. He told us to be here, and I object to him calling witnesses at 1:30 and 1:15. It's just not the way the court operates, that I have to start my case in the middle of his case, because I'm going to move for a directed verdict.
Well, I can take a recess. I haven't had a chance to review all the documents that have just been judicially noticed. If you'd like for me to step off the bench and you can wait here while I read the documents.
I'd like to also, I guess I can go over with him my exhibits also.
Why don't you do that? Because it just seems like it's a better use of everybody's time. I'm not prejudicing you from moving for a directed verdict. I'm just trying to be economical with everybody's time.
I understand, Your Honor.
So,
all I have testify as what's the reports. Not going to be supplied. So, coming in.
so do you want to show Mr. Sweetapple? You want to take a couple moments to show Mr. Sweetapple your exhibit? I'll step off the bench. You show him your exhibits. I'll take some of these and start reading them, and then you can come get me when you're ready.
Okay.
All right.
But I don't know if you can put any warning to it. Okay.
of the gentleman.
Thank you.
22. Relative value.
Oh. Friends.
You mean like written down?
Yeah, like they have a.
Sometimes, but actually I was a supervisor for 6 years before I left. And I wasn't a handy age. Hmm? I was. On my job though.
Statement regarding the.
Yeah.
Step it out a little.
Court's back in session.
Y'all can be seated. All right, Ms. Garcia is present. Madam Court Reporter is present. Mr. Sweetapple is present. Have you all gotten a chance to go over Ms. Garcia's evidence?
Yes.
All right. Are there any agreements to any of the evidence?
Limited.
Okay, let me see what Ms. Garcia has to present. Sure.
Authorization for identification is the death certificate of Mr. Walter Sahm.
Okay. Any legal objection?
Indicated. This, no issue is this, but it's totally relevant.
Well, it might not be relevant to your motion, but is it, Ms. Garcia has a motion to...
Yeah, my motion's not set for today, Your Honor, just the balance of this trial.
Okay.
I think it had been determined that if and when you rule on the settlement, then I would go ahead and do my discovery and set my 1.54 and 1.340.
So what is the relevance of this to...
The relevance to this is that you're going to see the orders and the pleadings that the gentleman died in 2021, and they continued to file pleadings in his name through 2024 without telling this court. They got final judgments. They go to the bankruptcy court claiming there's an estate issue, but then they had filed in his name there. And my testimony will explain the relevance of his date of death and what has happened since. It's very relevant to our defense.
All right. So I'll receive this into evidence over objection as defense exhibit. Is it 1 or 7? 7. Defense exhibit number 7.
So that was for identification. And then they did numbers, but it has defendant on. H is 7.
Honor, I noticed that you have a warning, no recording. I just want to make sure that the people on Zoom have been alerted that they should not be recording this. I see Mr. Hall and others on Zoom.
All right. So there's only one record that can be kept of a proceeding, and that is the court reporter's record. So any recording is not prohibited. It is prohibited. It's not the official court recording. That's by order of the chief judge and by order of me. What's next, Ms. Garcia?
Okay. If I may approach.
Sure.
Final judgment in this case?
Thank you. Any legal objection?
No, Your Honor.
I will receive it into evidence without objection as defense exhibit 8.
This one is J. The judicial notice, this was filed in his case, January 2nd, 2023 by me. I made my initial appearance.
Just note my objection to relevance, Judge. It has nothing to do with the competency issue and the brought on the court issue.
I guess what's the relevance of your motion?
The relevance of my motion, Your Honor, is I started from when I came in the case from day one, disclosing to the court all the issues with the fraud and filing for dead people and filing in cases, the bankruptcy cases for the state that had no rights, filing for Patricia Sahm.
Your Honor, the 1540 motion is not being heard today.
That's what my confusion is it seems, I'm not saying that this isn't relevant to your 1540 motion, but I'm trying to figure out what the relevance is to the motion that we're here for.
The relevance is, Your Honor, that they're coming in here with unclean hands. Like, for instance, on page 6, paragraph 11, Mr. Sweetapple continued to represent Walter Sahm after his death without informing the court. And even when there was a suggestion of death filed, he continued to file pleadings in Walter Sahm. Got a final judgment entered in the name of Walter Sahm, which was what was settled. So it's going to show that from day one in this case, there's been issues as far as the final judgment, the amount, the outstanding issues of 1.54 and 1.30 do affect the reasonableness of the settlement. So the court goes through this, the elements where you have whether or not they can even prove incapacitation at the time or not, since it was before the finding of the court. First of all, threshold issue. And then next, you have the issues that he's claiming, undue influence, fraud, and I'm not sure what else he's claimed.
Okay. I'm going to receive it into evidence over objection as plaintiff's exhibit 9.
Next one is K, Your Honor.
And if you can just tell the court whether or not I've objected to it or not.
This one you rejected to relevance, I believe.
Well, this is where this was hearsay. You're trying to, first of all, any communications from Mr. Raymond, I would require testimony to authenticate some form, and then there's an affidavit.
Oh, sorry, I'm so sorry.
An affidavit from a Mr.
We need to identify what it is for the record, and then
The email chain that I produced to counsel during the deposition when we were ordered to waive privilege or to appear and take privilege. And I produced a record, and this goes to the settlement negotiations between me, Mr. Raymond, and Mr. Sweetapple, and dealing in March of 2023 during the relevant time frame as to the capacity and the negotiations between the lawyers. And it's clearly when I'm asking questions of the attorneys and they're responding, this is the attorney for the estate. And that's relevant to the issues of filing the bankruptcy, claiming estate rights, not substituting the estate.
okay. So your objection to it is hearsay.
Well, in terms of find an affidavit by William Stanberry. She showed me an affidavit she wanted to put in, and
I don't have an affidavit.
I didn't attach that.
Okay, so yeah, I'm
objected.
You sure you're not going to move? You're going to agree with me that doesn't come in?
No, but I'm not doing it here. I'll do it separately. You told me I needed to bring
All
it
I
back.
have is an email.
All right. Well, first of all, there's representation that's sent to me, which is inaccurate. Second of all, you're going to learn that she sent numerous emails to a different email address than my email repeatedly in March and never included me on any of these, despite Mr. Raymond saying, include Mr. Sweetapple's in charge. He's handling this, not me. So if we get into these communications, I'm going to have to, for completeness, cross-examine her on the whole episode. And so I would object to this unless she comes in and testifies to authenticate, and I can ask her for completeness about other emails and what she did.
So your objection is it's not authenticated?
Yes, she would have to come in and testify. Mr. Raymond's not here, so she'd have to say, Mr. Raymond sent this to me, I received it, and then I'm going to ask her about other emails.
Okay. All right. Are you in a position to do that?
I can testify to receiving the emails.
All right. So then I'll have it marked for identification purposes, subject to it being authenticated. there's no other objection.
Yeah, I'm not calling her, but I anticipate cross-examining her based on.
I wasn't sure if there was it's highlighted indicating that the part that the court wants, she wants the court to consider is Mr. Raymond's statement, which seems to me to be hearsay, but if there's not an objection to that, then,
Well,
then it's just authenticity. We'll let it get authentic.
Well, I'm going to object on hearsay, Judge. I thought we had her statements here as well, so I will object to hearsay on anything just from Mr. Raymond.
Ms. Garcia, how is Mr. Raymond's statement not hearsay?
This email is our communication in relation to the settlement, and it's relevant. And when I asked him questions, he responded.
Right. So hearsay is a statement made out of court for the truth of the matter that's asserted. So how is it not hearsay?
It's an exception under the business rule. This is a communication for my law firm. It's a business record. This was received by me, and I can authenticate this as a business record.
Okay. And how is Mr. Raymond's statement to you not hearsay?
I guess I can test. Can I have one moment, Your Honor?
Sure.
I have no objection to her portion of emails coming in as long as she authenticates them and I have a chance to cross-examine her and bring in her other communications. To the extent she's just trying to put in Mr. Raymond's communications.
That's what I thought. I only thought that because it's highlighted in orange, but if that's
I don't have a highlighted copy.
That's not what you're seeking to do, then.
But she didn't give me the copy, highlighted.
This is what was handed.
Yeah, I didn't, that wasn't, I was looking at the bottom.
Here,
I didn't.
I'll give you one. So when he has where it was highlighted.
It's okay. I'm not trying to create issues. I just.
For one thing, Your Honor, there is an exception under party admission. Because this is where the other attorneys that I was negotiating with in this case, who represent the parties, are informing me that Ms. Sahm wasn't under guardianship and didn't need a guardian in March. So that goes to my mental impression of what was her status. And I will testify to different conversations and different mental impressions that I had and that Ms. Patwell had based on our conversation.
I'll have it marked for identification subject to being authenticated. That does sound like an exception to the hearsay.
And just so we're clear, I'm also objecting to relevance from this statement. And March, when we're on the subject of admissions by parties, representative and parties, I am going to be one of the exhibits I provided to the court because Ms. Garcia just provided me with the May settlement agreement she forwarded to Mr. Raymond that is signed by her clients where their repeated representation that Mrs. Sahm is incapacitated. That's in May. All right, this is in March.
Okay.
So just so the court for relevance and context, yeah, I'll be moving. We've already admitted that in evidence, but I'm going to ask the court to note that that is an admission of Ms. Garcia as the representative and the parties.
Okay.
I have just one moment.
Of course.
The next one, Your Honor, is marked as identification exhibit L. Yeah, the date of the answer.
All right, what's the plaintiff's position?
Objected to this hearsay, Judge.
Ms. Garcia?
I can call the witness.
Okay. I'll sustain the objection as to hearsay, but I'll have it marked for identification as L.
And note my objection also to relevance. If this witness doesn't have any testimony since March of 2022, it's not going to be relevant.
I've found that it's hearsay.
Just saying, when that witness comes in, I'm just reviewing that date of this.
The next one, Your Honor, is N. Letter signed by both parties, deceased Mr. Sahm and Mrs. Sahm as the trustee.
This is undated and hearsay, Your Honor.
It's a statement of a party opponent. It's also Mr. Sahm is deceased. It's a statement by him, which is the exception to the hearsay rule.
Where is that in the hearsay exception? Statement of a deceased person. Isn't it a statement of a person upon impending knowledge of death?
Your Honor, also relevance. It says a phone call October 11, 2019.
Isn't this prior to the final judgment?
Well, it's prior to the lawsuit being filed.
This goes to the relevance is that it goes to the long-term negotiations, because there's allegations that basically once we found out that there were some committee reports out there that we rushed to do a settlement, and this shows the court by statements by both parties that this has been going on for years. And it talks about the amount of $200,000 was a reasonable amount at the time, where they were willing to accept.
All right. I find that this is hearsay, so without an exception. So I'm going to sustain the objection unless it can be authenticated some other way. I don't see necessarily how it's relevant, but it is hearsay.
I could authenticate it by the receiver of the letter, who's here. I could testify, Your Honor, so. It's marked as defendant, Your Honor. It's a retainer by a trade traded tribunal dated April 11, 2023.
Hearsay, Your Honor. I would note, though, it is telling how the defendants have communications between an alleged attorney for Mrs. Sahm. This is a privileged document, and the fact they even have it is consistent with my theory of the case.
I'm going to overrule the objection. It appears to be a legal document, which it's words of operative legal effect, so that is an exception to hearsay. What number are we at? Number 10. We received an evidence over objection as exhibit number 10.
Honor, just if the court, if you'll note, I don't see, page 2, I don't see it signed by Mr. Weinstein.
It appears to be signed by the plaintiff.
Yeah, but we don't know if it's paid or anything about it.
And you'll be free to argue that to me
Okay.
as to why I should or should not consider it, but it appears that it's authentic and it appears that it would be admissible in the evidence. I'm going to receive it for whatever its evidentiary value is.
Your Honor, on page 15 is the email from Morgan Weinstein to Mr. Sweetapple. This deals with their communications in April 13th, 2023, when Mr. Weinstein was attempting to substitute in as the attorney in this case based on his retainer with the client.
All right, what's the plaintiff's position?
Top is from Kevin Hall.
This was
You're referring to just the Morgan Weinstein to me?
This was produced during a deposition pursuant to your court
Or
order.
you're talking about this section right here. Although Mr. Sahm she does not have an email address, but responds to her daughter Patty's email account. I've copied that account here. Mr. Sweetapple's asking you to email back to authorize the change in representation from his firm. So.
Is there an objection to that?
But just hearsay. I don't think it's complete either. I presume there's a response somewhere or follow up on any of this. Not relevant. It doesn't tend to prove or disprove anything.
It is relevant. Won't let me to respond.
This is hearsay from me. It's hearsay within hearsay. He's writing to Patricia Sahm, copying me saying that I have asked something to happen.
What, Ms. Garcia, what's it being offered? Is it being offered for the truth of what's being stated?
It's being offered for the fact that that this communication occurred and that Mr. Sweetapple was aware of the potential of substitution in this case on April 13th of 2023.
All right, the portion that indicates Mr. Sweetapple's asked the email back to authorize a change would be hearsay, but the fact that the communication occurred and Mr. Sweetapple's email is CC'd to the email is not hearsay. So I'll receive that portion of it in the evidence as 11. Defense exhibit number 11. Over objection.
Is there any follow-up email to this she's offering where that's something happened?
I don't know.
Okay, here is next email. It's exhibit Q for identification. Further communication. And Mr. Sweetapple and Patty Sahm Jr., she was communicating Mr. Sweetapple to see the power of attorney because Mr. Sweetapple had asked for a copy of the revocation of the power of attorney and requested that Mr. Weinstein, substitute in as her attorney.
I'm going to object to hearsay because I certainly want Patty Sahm to testify.
Garcia, what's the purpose of this email again?
The purpose of this email is to show the fact that there was communication and Mr. Sweetapple had knowledge that he was requested to substitute out and allow Mr. Weinstein to substitute in. And Mr. Sweetapple had asked for a copy of the power of attorney, and it was the revocation of the power of attorney was provided to him at that time, 4 days before the guardianship was filed.
There's no attachment to this. It says, I have attached my mom's revocation
The revocation.
And there's nothing attached to this email.
The revocation is already in evidence, Your Honor, as composite exhibit 1.
I'm going to receive this item of evidence I'm going to receive this exhibit into evidence over objection for the reasons stated by Ms. Garcia as defense exhibit number 12.
No, was that one P? I apologize. Q, okay. So 11 was that one, that was Q, okay. Then, R. Your Honor, marked as defense exhibit R. It's further email communications in relation to the same time frame. This was April 15, 2023, 2 days later, where
This is all hearsay from the daughter, who I believe is on house arrest still, but available by Zoom.
she's off in 2 days.
Pardon?
She's off in 2 days.
So you can call her by Zoom. I've been trying to unsuccessfully get her depot scheduled for months.
Not true. So, Your Honor, this goes again to the fact that at this time,
The hearsay is the objection.
Hang on. I need you to not all argue with each other. I need you to state your position so that I can make a ruling. So your objection is that it's hearsay. Ms. Garcia, how is it not hearsay? This communication between Mrs. Sahm and Morgan Weinstein, who's not Mr. Sweetapple or anybody employed with Mr. Sweetapple's firm.
well taken, Your Honor.
Sustained it.
If I want to admit it, I will call Ms. Sahm. Okay. Marked as defense exhibit S. T, I apologize, I scratched that.
Okay.
Your Honor, this is produced into the deposition.
My objection, Your Honor, is hearsay. These are texts with Ms. Patwell, who I've also been trying to depose, who's also incarcerated. So obviously anything that...
I need to know what Ms. Garcia's exhibit is, for the record,
Okay.
and then I'll ask you what your objection is.
So this is exhibit S, Your Honor, and this is the messages with Morgan Weinstein and myself, because our communications and our knowledge of what was going on at this time frame when we're being accused of committing fraud, taking advantage of somebody, you ordered us to produce these communications. So I produced the relevant communications from 4/10/2023 through 4/16/23. The last one is irrelevant here. Which basically is my communications with Mr. Weinstein, which I'll be testifying to, the fact that he told me he was being retained, he was filing his notice of appearance, I had to sign retainer, and
It's hearsay. Anything Mr. Weinstein said in these is hearsay.
And your statements, how are they not hearsay? I mean, if you're going to testify to it, that's subject to cross-examination. I don't see how this is an exception in the hearsay.
This is a business record, Your Honor. This is my communications with opposing counsel that I was ordered to produce in a deposition, which I produced in a deposition, was subject to cross-examination at the deposition.
I haven't heard that it's a business record. I mean, it may be. I haven't heard that.
This is kept in a regular course of business, communications with opposing counsel, communications with my clients. In this particular document, you ordered us to produce the communications. So I did. He's had the benefit of it, has cross-examined.
Just because I ordered it produced doesn't mean it's admissible into evidence. It means that perhaps he would like to admit it into evidence as a statement that you made. I don't know, which would be an exception to hearsay. But if you are asking to admit it, I need to find out how it's admissible.
And anything that's her communication, I'd want her to authenticate, but I'd be objecting to anything Mr. Weinstein.
Right.
This is an authorized admission, Your Honor. Federal Rule of Evidence 801 B2 CD. Supposedly there's a conspiracy. This would be an admission of a co-conspirator also under his theory, under 801 B2E. It's also an adoptive admission.
Who's the co-conspirator?
So that would be an exception that he would seek to admit it under, unless you're conceding that you're part of a conspiracy and you're saying that you wanted to introduce your co-conspirator statement.
No.
Is that what you're?
No, I'm not saying that we are conspirators. I'm saying we've been accused of conspiracy. We've been accused of fraud.
I will reserve on ruling on it, but as of right now, it sounds like it's hearsay without an exception.
But then also, this whole thing about Mr. Weinstein is irrelevant. There's no dispute. I was never provided with a proposed substitution of any form.
It may ultimately be irrelevant, but
I mean, we're on a wasting time.
well, your witnesses aren't available till 1 o'clock.
I know, I understand, but
At 1:30, so we have to get this. It would have been nice to have some agreements to some of this to streamline things, but there was an objection to even waiting till 1:30. So let's use our time wisely.
Here's you, Your Honor. That's you. This is a key brief that you from notice.
I had no objection to this. It's Mr. Schraberg's fee agreement from the bankruptcy court. He represented the estate and Patricia Sahm individually.
So you have no objection to receiving defense you into evidence?
That's correct. In bankruptcy court, you're required to file your fee agreement, so there's really no privilege at this point.
Received in evidence without objection as 13, defense 13.
Exhibit V, Your Honor. It's reported an examining committee member. One of the 3 committee members officially signed the case.
This is the one who's going to be testifying second. I have no objection.
I'll receive it in evidence without objection as defense 14.
So that was V allowed as 14, Your Honor?
Yes, ma'am.
Thank you. Exhibit W.
May save some time. We're discussing, we may waive calling this witness if she's allowing this and that.
Okay.
Sorry, that's W. Your Honor, Exhibit W is a report.
This is not filed. This is.
Sugar.
Yeah, I need her to tell me what it
and
is,
it's-
and you to tell me why I should or should
I
not.
thought she was finished.
It's okay.
No. And this one is being moved in for the fact that it was prepared, just like the other ones that you had allowed, that although it's hearsay, the fact that this report exists, so I can testify to the relevance of it in my testimony.
Your Honor, this is not a appointed examiner. This is somebody they went out and hired. It's not filed in the case. It wasn't part of Judge Burton's review. And it's hearsay.
It is hearsay. The other one was not objected to. This one is objected to. It's
And it
hearsay.
said the doctor who they testified had a high holy day and couldn't be here. We had to continue so he could be here. So obviously there's no prejudice. They know that if they want to call Dr. Sugar, he has to be here.
Dr. Sugar's report is hearsay. I'm sustaining the objection.
Your Honor, I'm moving in not for the contents, but the fact that it was prepared and the date it was prepared. You had allowed the other reports the same purpose, saying it was hearsay. So I'm not moving in for the contents of the report, moving in for the fact that it was prepared, when it was prepared, and the relevance, in my mind, of this report.
It's all hearsay.
No, it's not hearsay, because I'm not going to discuss the relevance of the report.
I will allow you to testify to the fact that a report was prepared, when it was prepared, and that you received it. But the substance of the report is hearsay.
Understood.
Without an exception. So I'm sustaining the objection to the physical report.
But it's allowed for the fact that it was prepared?
Yes, you can testify to that, yes. I think you have testified.
I think we started, Your Honor.
It's identification.
Okay, the next one, Your Honor, is Composite Exhibit Y. And it entails the promissory note in this case.
These are attached to the complaint and the court file. I have no objection. They're not relevant. I have no objection.
I'll receive them in evidence without objection as composite exhibit 15. How many composites are there? 15A and B?
Note and mortgages, amended mortgage.
So A and B. No mortgage.
Exhibit Y.
So I'm going to make the promissory note is 15A, and then the mortgage is 15B. They received the evidence without objection.
I'm sorry, was the V, which was the Cheshire report, that was admitted as Exhibit 14?
I stipulated for that.
Right, so that's
Correct.
14.
Yes, ma'am.
They save us time.
So this one was Exhibit 15. Defense ID to me, Your Honor. I believe that he agreed to the judicial notice.
No objection to judicial notice of this. It's in the court file in this case.
It'll be received in evidence without objection as Defense Exhibit 16.
That was Defense D, is Defendant 16.
Yes, ma'am.
Thank you, Your Honor. Is Defendants AA. AA. And this is a state record showing that the Bernstein Family Realty LLC was active as a reinstatement on the relevant time frame, March 16th, 2023.
And Your Honor, it was then dissolved administratively not long after that. And as long as I can put in that to show that it's not currently in good standing, I have no objection as long as I can put in the current document that shows the actual date of dissolution.
Any issues with that, Ms. Corsi?
I'm sorry?
Any issues with what Mr. Sweetapple proposes?
I have not seen what he's talking about, so that's what the public record shows. I don't have a problem with that one also coming in.
Is that what the public
Be
record shows?
composite.
Yes, Your Honor, it's the same printout from Sunbiz.
All right, so then
But-
I'll allow his in if I'll allow Ms. Garcia's. So it'll be received by stipulation as Defense Exhibit 17.
Yes. It's
We'll
composite,
provide that to the court. We'll print it during lunch.
No
so I
problem.
guess I would call it composite 17, since he's going to add the second.
He's going to add it as plaintiff's exhibit, whatever.
Stipulates this judicial notice that is defendants BB, which is a suggested bankruptcy filed in this case, 4/3/23.
Position of the defense or the plaintiff.
No, I have no objection to the court taking it in the court file.
It'll be received in evidence without objection as Defense Exhibit 19.
18.
A lawyer, I can only count so long.
Okay. Defense for identification CP against a judicial notice, Your Honor. This is a filing in this case, so filing the guardianship in the mental health case, my hearing for Patricia Ann Sahm Jr. dated 8/14/23.
Position of the plaintiff.
No objection.
Be received in evidence without objection. Defense 19.
19.
I'm back. 19.
Getting near the end. Okay, then we have defense ED, which is a 5/22/23, again, judicial notice. Ms. Patwell notice of hearing to this case, filed May 22nd, 2023.
Position
No objection.
be received in evidence without objection as Defense Exhibit number 20.
Defendants EE for identification, Your Honor. Stipulation to substitute the counsel signed by Patricia Sahm.
This is hearsay. It wasn't Doesn't show it was filed.
I thought this was produced in our August hearing and received into evidence.
I believe, let me see, stipulation for substitution, yeah, it's defendants.
That was me and that sign. This is Laurel Buckle.
Let me see, plaintiff, it was defendants, D, and it was admitted as Exhibit 3 already, Your Honor, evidence 3.
This is already in?
Yeah,
No.
I believe, I'd have to compare it.
So the original exhibit that was put in as defendant's D was an unfiled stipulation for substitution that was signed by Patty Sahm Sr., but was signed by the attorneys in this.
That's what this is.
That's for Laura Bull. That was for,
This is the probate court, Judge.
that's the probate court in front of you.
This is not.
This is
our
The
case.
MH, no, I'm sorry. You're right, Your Honor, I
This is
apologize.
2018 CF. That's this case.
No, Your Honor, I apologize, it's the wrong, let me take that back and refresh. No, this is a stipulation for substitution of counsel in the mental health case where Patwell.
It's 2018 CA 2317. That's this case number. What you've handed me, perhaps you handed me the wrong
Handed you the
document.
wrong one. What is yours? The MH case? I didn't hand you that.
It says probate division on top. The one that went
I
into
think
evidence.
you have a different paper than I do. What I'm saying. I have this one. That's this. Okay.
Sorry.
That's what we.
For the end.
This is what we.
This is here.
Okay. Hang on.
Now I've got to I'm going to have to mark it correctly.
No problem. No problem.
If she has this one filed in the case, I have no problem with the judicial notice, but she's handed me a stipulation for substitution counsel probate case, allegedly signed by Patricia Sahm and nobody else and no date.
This was EE.
So this is the stipulation in 2023 MH 1072.
Yeah. This is the one in the mental health case to show that Ms. Patwell substituted in for Laura Burkhalter. And this is the stipulation signed by the client. I think we've already moved into evidence and notice of appearance. So I guess it could have really been attached to that, but I have it separate.
Noting your objection, I'm going to receive it in evidence as defense exhibit number 21.
Yeah, just correcting it.
No problem.
They're marked as defense FF. This is in the public records. This is the second mortgage in the property in this case. This is reported.
No objection, except the relevance.
You'll tell me why it's relevant or not. I'll receive it in evidence without objection as 22, defense 22.
And we have defense exhibit GE, the letter from the law firm
Hearsay.
to Ms. Atwell, Mr. Bennett, terminating Mrs. Sahm terminating, or attempting, I should say, to terminate Amber Patwell August 1st, 2023. And the attorney is present here for the, is Mr. Rivard present?
Pardon?
Is Mr. Rivard present?
He's not present here, no.
Is he on Zoom?
Haven't even looked. Is the board on Zoom? Anyone?
Sure.
Don't object.
Ms. Garcia?
I would move it in, Your Honor, not for the truth of the matter asserted, but the fact that this letter was sent.
It does appear to be words of operative legal effect seeking to terminate an attorney-client relationship, so I'm going to receive it over objection as Defense Exhibit 23.
23. The next one is Defense Exhibit HH, which is a filing which is stipulated to for the record in the estate case of Walter Sahm. This is the statement regarding creditors.
Look at all this
And
handwritten.
the handwriting is my notes, which I will testify to those notes as far as that was from my conversations with Mr. Raymond when we were settling the case. We were going over the estate's rights, and I'll testify to the relevance of it during my testimony.
First of all, number 3 says there's something attached, list of creditors. And I don't see anything attached to this. Second of all, I don't see how this is relevant. The estate has no claim in this case. The estate has never had a claim in this case.
In an abundance of caution over your objection, I'm going to receive it into evidence as Defense Exhibit 24.
Your Honor. It's a Ms. Patwell's response to the guardian's request for production that was delivered to us in the guardianship case.
No, this wasn't filed with the court, and it's hearsay.
These are all the documents that they requested to be produced by Ms. Patwell. And this goes to the mental impressions of her and I's negotiations and what she produced to the court. It's very relevant to the issues of fact as far as communications by Ms. Patwell. It's got the mental impressions that Judge Burton had read into the court.
I have a right to cross-examine Ms. Patwell about her writings and mental impressions and everything else. That's why we have a hearsay rule.
I mean, this does appear to be classical hearsay. So at this time, I'm going to sustain the objection on a hearsay basis. Subject to you seeking to admit it some other way. But it's hearsay right now. So identification only.
This is JJ, Your Honor. This is the
No objection.
this actually would probably really tie in.
It doesn't sound like there's an objection, so what is it?
Okay. This is the actual executed stipulation of substitution of counsel, where I have already moved into evidence the one time by the Church of Providence with the fully executed or filed stipulation. And it also has the proof of the delivery.
And the order
Yeah, and then the order substituting Ms. Patwell in as the attorney for Ms. Sahm.
will be received into evidence as Defense Exhibit 24, 25.
A defendant's exhibit KK, which is Mrs. Patwell's agreement under the legal rule. And this is executed by Ms. Patwell. Ms. Sahm dated May 1st, 2023, been provided to the court in the mental health case in through discovery. And it is an exception to the hearsay rule.
You've already determined that retainer agreements are exception.
Received into evidence. Is there an objection?
Pardon?
Is there an objection?
Well, I'm object to hearsay,
Or
but
receive it into evidence over objection?
I think correctly made a,
Defense 26. Well,
make a record, but
just ask.
I don't think I go any further than that.
Just ask.
I think we've already moved the settlement agreement, fully executed settlement agreement in, let me see something.
Did you put X?
E. No,
I have it as
I think it's exhibit 6, defense exhibit 6.
yes. I have it as Exhibit 6 entered in on August 12th.
Okay. I don't know if you needed a copy, if you have a copy from last time.
The Madam Clerk.
Which date, which one is this, May or?
The May 22nd agreement.
Okay.
So it's already in there.
And then you had a copy of the prior agreement signed by your clients.
Yeah, I'm not using it.
Okay, well, I want, Your Honor, she produced at a deposition a document that I put into evidence that she stipulated to. She did not give me the copy that was signed by her. Her client signed a settlement agreement referencing Mrs. Sahm was incapacitated repeatedly. So I do ask that she produce here the complete document, not the one she gave me at the deposition.
Do you have that document?
Ms. Garcia?
Ms. Garcia? Do you have that document, Ms. Garcia?
No, I don't intend on using it.
Right, but wasn't it ordered to be turned over? And it wasn't turned over? So shouldn't it have been turned over?
No, it was turned over.
Not with the
The
signatures.
depositions.
Not with the signatures. I put in evidence what I was given by her. I don't have signatures.
Do you have one with the signatures?
Yeah.
Well, I said I wanted.
It's marked as exhibit X.
You don't have to enter it as evidence, but
I-
he's entitled to it, and he may want me to receive it as evidence. It sounds like he does, so.
I'm going to substitute this. And when I was presented with this, I said, I want to substitute this for what's in evidence. I did not object to hearsay. So this is a settlement agreement signed by the Bernstein side on March 11th, and it is being substituted. I think it's 5. Or it can be an addition.
Ms. Garcia, what's your position with respect to I guess you have the same position that you did when they moved plaintiffs 5?
I'm sorry, Your Honor?
Do you have the same position that you did when they moved plaintiff's exhibit number 5 into evidence? For any additional?
Let me see, plaintiff's 5 was not accepted. I don't see it anywhere. There is no plaintiff's 5. So,
Madam Clerk's indicating it was received without objection. You have the date, Madam Clerk? At 11:09 today. I know we've been working hard, but apparently it was submitted at 11:10.
I'm sorry?
Yes, sorry, right here. Yeah, it's this one. This is how it starts.
Yes, that's a transmission.
So do you have any additional objections to this signed?
No, Your Honor. So what numbers did I apologize. I lost.
I'm not going to substitute it. I'm going to receive it in evidence as what's plaintiff up to? 12. I'm going to receive this one, the signed one, as plaintiff's exhibit number 12.
Is there an ID number or just exhibit 12?
Exhibit number 12. ID 12, exhibit 12.
Yeah, Your Honor. What was plaintiff's 11? I don't see an 11. I have that as 10. 5, 6, 7, 8, 9, 10.
10 was another order.
An order appointing a limited guardian is 9, and an order granting. It was the objection, right, to the examination committee? 9 is the notice of appearance, and 10 is the order, 11 and 12, okay.
Madam Clerk, you don't have to apologize. You're fine.
Thank you, Your Honor.
Yes, ma'am.
Your Honor, I do have the Sunbiz report that I've been as 13.
All right.
Council wants to take a look at it. Are you finished? I'm sorry.
No,
I thought you were finished.
no, 2 more. Okay. We've already done this one. And then oh, wait, I'm sorry. This one. First order, I have to put it in the right order for you. Here's one in the right order.
Good.
Okay, this is fence MM for identification. Me and Mrs. Atwell. The relevant time frame. May 1st, 2023 through May 22nd, 2023.
Check the hearsay and anything that Ms. Garcia wrote, she can certainly authenticate and testify to in court.
All right, Ms. Garcia?
I guess the same objections last time. This is a business record. This is my statements. Also, business record. And it's a statement of previously existing state of mind.
I'm going to sustain the objection as to hearsay. Those be marked for identification purposes as MM.
That's it for now, Your Honor.
And Your Honor, Ms. Garcia, if you want to take a look at this, I do have the current Sunday's filing showing dissolution as of September 27, 2024.
Do you have a copy for me and a copy for the court?
I only printed it out.
Okay, so this is,
Plaintiff's 13. Any issues with plaintiff's 13?
no, Your Honor.
Proceed by stipulation of parties. Plaintiffs agree with on 13.
Thank you for your patience, Your Honor.
Do you have additional documents that you need to admit?
I'm sorry?
Do you have any additional documents that you need to admit?
Not at the moment, no, Your Honor.
So we have your witness that's
Yeah,
set to go.
we're discussing whether or not we can save time by just calling Dr. Bloom since she stipulated to Dr. Chesser. I don't know if she stipulated Dr. Bloom or not. We put it in just for judicial notice prior here.
I
Do
don't
you have
know.
any objection to Dr. Bloom's report?
Yes, I definitely would like to cross-examine Dr. Phil.
Okay. Is Dr. Bloom available at
1:30.
All right. So do you want to take a 15-minute break and then we'll get back together at 1:30 and we'll pick up with your next witness?
What I'd like to do is have an hour-long lunch during 15 minutes. And that isn't going to happen.
Well, what I'd like to do is after that witness, do you have any other witnesses or evidence?
I'm discussing with Ms. Lewis, just trying to save time because I want to get through this today. So I may not call Dr. Cheshire. She has a complete
Okay.
report.
That's fine. So you have one, possibly two other witnesses. Anything other than the two doctors?
If Mr. Bernstein does not show up, I'm going to read 3 snippets from his party deposition.
Okay. And then Ms. Garcia, how many witnesses?
That would be proper without proper presentation.
How many witnesses do you intend on calling?
Depending on what happens with Dr. Bloom, 1 or 2.
Okay. So what I'll do is we'll take 15. We'll get your one witness on. If you decide whether or not you're going to call Dr. Cheshire, then maybe we'll do both of them and then we'll break. I'll give you guys an hour for lunch and then I'll let Ms. Garcia make her motion and call her witnesses depending on my ruling on her motion. And then we should have all of the evidence in so that this portion can be submitted to the court. Sound good?
Yeah, except I will read a party deposition for less than 60 seconds.
We'll take that up at the appropriate time. All right, I'll be back in, I guess now it's 10 minutes.
Thank you.
You.
Are we ready?
Yes.
Do you have a copy of the two reports that you moved with the evidence?
Pardon?
Do you have a copy of the reports? Mm-hmm. The notice of filing, I guess you did.
We have a copy to
Come to order, reports back in session.
Everybody can be seated. Looks like everybody's back. Mr. Sweetapple, let me turn it over to you to call your next witness.
Thank you, Your Honor. May it please the court. Before I do, I'm going to ask if Ms. Lewis can assist us here. I am led to believe that this mental health
I'll call
report.
you back. I just got a call from a court. I'll call you back. Bye.
That this report would need to be under seal, and also that no one other than the doctor can be observing this presentation. So I'll let Ms. Lewis address that. I'm not an expert in guardianship or mental health.
There was an incident in Guardianship Canada where somebody refused obtained copies of the original committee reports and statements. Did a story about Mr. Sahm and showed copies of her confidential medical committee reports on, I think it was CBS 12. So we have a concern that if there are public observers on the Zoom, because we have no idea who those reports are, they are people who have attempted to use regarding health, that they would take that testimony and go back to the press. Because this is information that would be confidential. Guardianship involves very sensitive information. We believe that Mr. Sweetapple is going to ask the court to dismiss the observer.
All right.
That is correct. I am making that request based.
Ms. Garcia?
I'm going to object to that. This is an open and public courtroom. They're the ones that are bringing this issue up. They want you to make a determination of someone's capacity at a certain date and time based on the testimony of a committee member. So I firmly believe this is open. They are the ones that brought it out into the open. They're the ones that have moved this into evidence.
I guess while the guardianship proceedings are certainly have a different level of privacy, this is it's a foreclosure action. So I guess what authority do I have to prohibit the public from having access to the court? Is there a statute or anything that says that? Because let's say, for example, this was a car crash and it was a loss of consortium claim, or there was testimony about a traumatic brain injury or something like that, where it would be the same issues. It would still be a public courtroom. I wouldn't be able to deny the public access.
Your Honor, may I speak?
Are you counsel of record?
No, I'm not. My name is Ms. Hogue. I'm a member of the Guardianship Improvement Task Force, and if I could just say nothing about any of the...
I'd object. Your Honor.
Even in probate hearings, there's a statute, and it says a closed probate hearing is forbidden. The only person, it's Rule 5.540 hearings, and it specifically says an election to close the hearing may be made before the hearing by filing a written notice, and the only person that can close it is that person who's been adjudicated incapacitated. So even if this was a probate proceeding, okay, hearings are open. So I'll put myself on mute and thank you, Your Honor.
Okay. Thank you, ma'am. I don't see any legal basis to close a circuit civil proceeding that is not a probate action. It's not a guardianship action.
And what about sealing the reports that are in evidence?
If the reports that are in evidence are reports from the proceedings, then I think there is a basis to seal that evidence because it's evidence that comes from a closed proceeding. So I would order that those be sealed pending further order of the court. But as far as the testimony, I'm not going to dismiss the observers.
Understood.
That's
Gotcha.
May I proceed?
Sure.
Thank you.
Who are you calling?
I'm calling Dr. Bloom.
Dr. Bloom? Dr. Bloom, would you raise your right hand for me? Dr. Bloom, can you hear me? Dr. Bloom, can you hear me?
Is he on mute?
He's not on mute. He's not responding. Dr. Bloom? He can't hear. Is he connected to audio? It looks like he's connected to audio. Let's see if I mute him and ask him to unmute himself. Let's see if that works. Dr. Bloom, can you hear us? Perhaps if he disconnects and reconnects, can someone communicate with him to ask him to disconnect and reconnect? Mr. Bloom, can you hear us? Or Dr. Bloom, can you hear us?
You can write a note on the screen.
It comes up reversed.
Does it?
Learn that the hard way.
You've done that.
I can try to send him in a chat. Dr. Bloom, can you please try to reconnect? He may need to turn up speakers on his computer. Does anybody have Dr. Bloom's phone number to call him?
Because he's on the green.
See the green coming up.
That's why I think perhaps his speakers are just not.
Can we chat to him to turn up the speakers?
I have asked him to reconnect. He's not responding. He's not doing anything.
He's not getting the chats. Cindy, why don't you see it?
Can you hear me?
Yes.
I can't hear you.
Can you hear me from here?
And my unmute is, I'm unmuted.
Right, we can hear you.
Can you hear us now?
think it's his computer speakers.
Pardon?
I think it's his computer speakers. He either needs to reconnect or...
Okay, looks like he's...
It wasn't me. I like it, but it wasn't me. No. Honesty is the best policy. I'm going to use it. So he's just turned his video off, though. Maybe can you tell him to give you a phone call? Reconnecting. Paging Dr. Bloom. Can you hear us? Are you able to hear us, sir?
Hello. Hi, I'm not hearing. That's what
Yeah, that's not on you.
I didn't see that, but I'll try it again. Okay.
He indicated that he would try again. Okay. Right. Do you want me to step off the bench so that we can work out the AV kinks and then I'll come back once it's working?
I have no
You want
problem.
me to stare at you all while we're working our way through?
How about if we just see if this miraculously works before we do that? Dr. Bloom, can you hear me?
Does not appear that he can hear you.
No, it does not. So how about if we just ask the bailiff to summon you when we're
All right.
working? Thank you. Dr. Bloom, can you hear us? Or do we need to use
I can try it on my phone.
Yeah.
Shall we talk on the phone or what?
Can you hear me from here, doctor? Can you
Yeah,
hear
I can
me?
hear you.
Okay, let's see if we can get it. So we could do it through the phone.
I do not have that. All I have is a a microphone that says mute or unmute.
Okay, nothing on hearing us, no volume control? You checked your volume control?
There's no join audio. It just says mute. It just shows a microphone. And when I speak, the microphone reacts.
Whose phone are we listening to?
I can try it on my phone.
Yeah, let's see if
better.
Yeah, this seems to work. Let's go ahead and can we get the judge? I think this here's he can hear counsel.
Give me a minute and I'll try it on my phone.
No, just do what you're doing because this is working. Okay.
I'm trying.
Well, what's wrong with you holding it? Dr. Bloom, can you hear us? Dr. Bloom, can you hear us? We were just...
Yes.
Can you hear me?
I hear you.
Fine, okay. Your Honor, may we proceed?
Sure. Dr. Bloom, can you raise your right hand for me? He can't hear me. I think it's because you're talking on the phone. So what Dr. Bloom's going to need to do is he's going to need to put his video on mute, or I can mute him.
I hear you now.
Can you hear me now?
Yeah.
Can you raise your right hand for me?
Yes.
Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right. You can put your hand in now. And Mr. Sweetapple, you may inquire.
Thank you, Your Honor. May it please the court. Dr. Bloom, would you please state your full name for the record?
Stanley Bloom.
And are you a licensed medical doctor?
Say again, please.
Are you a licensed medical doctor?
Yes, I am.
And how long have you been licensed?
About 50 years.
And where are you licensed?
In New York and New Jersey.
And have you ever been appointed by a Florida court to conduct an examination of an alleged incompetent or incapacitated?
Yes, I have.
On how many occasions have you been so appointed?
Say again, please.
For how many years have you been appointed by Florida courts to?
Since 2013.
So, a dozen years?
Yeah.
And how many examinations of alleged incapacitated persons have you conducted for the Florida courts?
I average about 150 to 200 a year, about 1,000.
And do you have your records in front of you regarding an examination you conducted on May 5th?
Yes, I do.
23 of Patricia Sahm. You have that?
Yes, I do.
All right. And can you tell the court what you did on that date?
Say again, please.
Can you tell the court what you did on that date?
I interviewed the alleged incapacitated person.
All right. And how long did you spend with her?
It's over a year ago. I couldn't tell you.
All right. And that was on Zoom, was it not?
Hmm?
All right. And do you remember your mental diagnosis of her, or would you need to review your records?
No, I remember. I thought she had dementia, probably Alzheimer's type.
All right.
Definition of foundation.
What part of the foundation is lacking?
Pardon?
There was an objection, and I asked for clarification on the objection.
Typically in this case, as far as appointment, was he even appointed?
Overruled.
Were you appointed by Judge Burton to conduct an examination of Patricia Sahm?
I did, Are you talking to me?
Yes, sir. Were you appointed by Judge Burton to conduct this examination of Mrs. Sahm?
Yes, I was.
All right. And under mental diagnosis, what did you conclude?
I concluded that she had dementia. She had a loss of long and short-term memory. She was cognitively impaired, and she was not oriented in time, place, or person.
Was she clear regarding her finances?
No.
Did she know specifics regarding her assets?
No.
Did she know how much money she had?
No.
Was she aware of the guardianship?
She didn't understand the concept.
Did she remember receiving copies of the petition?
I didn't ask her that specifically.
Okay. And did she remember seeing her attorney?
I didn't. She did not.
All right. Did she know what medication she was taking?
No, she did not.
Did she know who the governor or vice president is?
No.
Could she multiply 9 times 7?
Could she what?
Multiply 9 times 7.
No.
Did she know how many quarters are in $6?
No.
Could she subtract 7 from 100 serially?
No.
Was she aware of the pending litigation regarding this property?
No.
And what is a MOCA score?
Say again, please.
What is an MOCA score?
I'm having trouble hearing you.
I see in your report that her MOCA score is 18 out of 30. What is that?
Yeah, she had a MOCA score of 18.
Can you explain to the court what that is? What is a MOCA score?
That's a screening test for Alzheimer's disease. I did not perform the test, but I saw the report from another examining member community.
Right. And
who had performed it.
I see in your report that Stephanie Cheshire and Brennan Cheshire were present.
She did that examination.
So you did review a MOCA score regarding her Alzheimer's?
Yeah, with Stephanie.
Right. And what does the score of 18 out of 30 indicate?
It indicates there's a cognitive impairment. It's a screening test, but it indicates above 17 indicates moderately severe cognitive impairment, disability.
And she had these conditions on May 5?
Hang on. There's an objection.
Did she what?
There's an objection to foundation. The objection is overruled. Next question.
Thank you. Did she have these conditions when you saw her on May 5, 2023?
Yes.
And did you consult with Dr. Cheshire and Mrs. Cheshire regarding?
Yes, I did.
And I see that you did a functional assessment. Did you find that Ms. Sahm is able to travel alone on public transportation?
Objection, meeting.
I did not think so.
Overruled.
No.
Did you find that she was able to drive her own car?
No.
Did you find she was able to shop alone for food and clothing?
No.
Okay. And those were your findings? No?
No.
What did you find with regard to her ability to take her own medication?
I thought she did not have the ability to manage her medication.
What did you find with regard to her ability to manage her own or handle her own money?
I thought she did not have that ability as well.
Right. So you were asked in Section 6 to indicate if you thought Ms. Sahm lacked the ability to exercise the following rights. Did you, in fact, find that she lacked the ability to knowingly marry?
Yes.
And what about the contract? Did she lack the ability to contract?
Yes.
Did she lack the ability or to exercise the right to have a driver's license?
Yes.
And to travel?
Yes.
Did she lack the right to seek employment?
Yes.
and to determine her own residence?
Yes.
Did she lack the ability to consent to medical treatment?
Yes.
Did she lack the ability to apply for government benefits?
Yes.
Did she lack the ability to sue or be sued?
Yes.
And what about manage or dispose of her property?
Yes, lack the ability.
All right. And did you sign a report for the court on May 5th, 2023?
Yes.
All right. And I can show them a copy on the screen if needed, Judge, to see have them authenticated. Is that necessary?
You're seeking to enter it into evidence?
Yes.
How would it not be hearsay?
Pardon?
How would it not be hearsay?
All right, so I won't move it in. So you did issue a report, correct?
Correct.
And provided it to Judge Burton?
Over.
Say again?
You did issue a report and provided it to Judge Burton?
Yes.
Were you asked to testify at any proceeding?
Yes.
All right, and did you give testimony consistent with that testimony you've given today?
I didn't what?
Did you give testimony in the proceeding before Judge Burton consistent with the proceeding, with the testimony you gave today?
You're breaking up. I'm sorry.
I apologize. Did you give testimony in the proceeding before Judge Burton that was consistent with that testimony you gave here today?
Yes.
Okay. And these conditions that you have described here, could they have just occurred the day before the meeting or the week before your examination?
No.
Overruled.
Unlikely.
All right. How long do you believe these conditions were present?
Well, Alzheimer's disease is a slowly progressive, irreversible disease that occurs over time and is not an acute disease.
And so over how long of a period do you believe she's progressed to this stage?
It's hard to say. It's been presumably some time, but I can't say when it began.
With respect to the speculation objections, the doctor has testified he's a licensed doctor for approximately 50 years in 2 states. He's been testified that he has, for the past 12 years, been appointed to inspect incapacitated persons. He's inspected approximately 1,000 individuals in total. I find that he has established that he's qualified to render an opinion. So I'm overruling the speculation objections.
Based on a MoCA score of 18 out of 30, has this been an acute case of Alzheimer and dementia?
That test does not distinguish acute versus anything. It's just a screening test for cognitive ability.
All right, and you don't rely on that exclusively, do you? You do not rely on the MoCA test exclusively. You interviewed the patient, correct?
I'm sorry, you're breaking up again. I'm sorry.
I take it you do not rely on the MoCA screening test alone. You do a detailed interview of the patient, correct?
I don't rely exclusively on the screening test to render my opinion.
If I could have one moment, Your Honor.
You may.
Thank you, Doctor. I have no further questions at this time.
All right, cross-examination.
Thank you.
Ms. Garcia, it might help if you're by that microphone. I think his audio is coming from that phone.
On the phone.
Yeah.
Good afternoon, Dr. Bloom.
Good afternoon.
Nice to meet you, sir. When asked a question on direct about your report and your findings, you testified that you found that Ms. Sahm had dementia, correct?
Can you lower the microphone? Maybe I can hear you better. Not that low.
I'm short.
Okay.
On direct, you testified that your report made a finding that Ms. Sahm had dementia, correct?
I'm really sorry you're breaking up. On the report, what?
You testified that Ms. Sahm had dementia?
When we were asked the question about your findings, isn't it true that you testified that your report stated that Ms. Sahm had dementia?
Did my report state it? In the report, I'd have to read the report to see if it was stated there. I can't tell you what off the top of my head.
Do you have the report in front of you, sir?
Yes, I do.
Could you please refer to your report, page 1?
Which report do you want? The 23rd? The first one or the second one?
The first one, Your Honor. I'm sorry, the first one. Dr.
I don't have a third one. I have a first and second one.
She said the first one.
The report dated that that the attorney had read the statements off the report to you, and you were confirming what he was saying. Your report dated May 5th, 2023.
Yeah, that's good. I can hear you now. Yeah, okay. What about it?
Isn't it true that on direct you testified that your report stated that Sahm had dementia?
No, I testified that I believe she had dementia. I didn't testify the report had dementia.
Isn't it true that in your report you only stated she had long-term or short-term memory?
She has loss of long and short-term memory, correct.
How long, first of all, how did you appear at this evaluation? Were you there in person or on Zoom?
I'm sorry.
How were you there to analyze or to evaluate Ms. Sahm?
I interview her.
Did you do it in person or on Zoom?
I believe I did it on Zoom. My memory is a little vague on it. It's a long time ago, but I believe I did it on Zoom.
And when you did this review of Sahm, was Stephanie Cheshire and Brennan Cheshire present at that?
You know, I did 2 exams on her, and they're over a year ago, and I know I did one remotely, and I know I recall at least in one of them that Stephanie Cheshire was there, but I can't tell you which one or, you know, when they were there. It's too long ago.
Isn't it true that these reports and these evaluations are supposed to be done independently of the other committee members?
When we're trained, we're encouraged to review our reports with other members of the examining committee.
But you can't rely on their findings.
I do not rely on their findings.
But you relied on the MOCA test, the score of 18 out of 30, correct?
I rely on my interview, any medical information that I receive, any discussions I have with members of the examining committee, the medical past history, the psychiatric report, which I have access to, and any other information that is made available to me. I do not rely on any one specific thing.
Didn't you testify on a direct examination that a MOCA score of 18 was...
When you talk directly into the microphone, you get real close, I can't hear you.
In your direct testimony. Am I correct when in your direct testimony, you testified that a MOCA score of 18 is an acute cognitive deficiency, correct?
Incorrect. I did not say acute.
So when the attorney told you it was acute, you said, yes, that's not true? That an 18 is actually a mild cognitive impairment function?
It indicates that there's significant cognitive impairment. That's what I stated. and that's what I mean.
So who conducted the MOCA test in this? Out of
Stephanie
the three of you.
Cheshire. Stephanie Cheshire.
She doesn't have the ability to conduct MOCA tests legally? She doesn't have the training or certificate?
That's not true because I've done other cases with her, and in fact, she is trained to do it.
Overruled.
You said Stephanie is the one who conducted it? Mrs. Stephanie Cheshire? Correct?
You have to get close to the microphone again, please.
Did you state that Stephanie Cheshire is the person that conducted the MOCA test?
Stephanie Cheshire is the person that performed the test.
Correct. Stephanie Cheshire, the social worker?
I believe she is, but I'm not intimately familiar with her credentials. I'm sure they're available to you if you wish to see them.
Are you aware that Stephanie Cheshire allowed her social worker status to expire and she's still conducting MOCA tests illegally?
I don't know if that's factual or not. I can't tell you.
Speculation. And he doesn't know. Next question.
How long were you on the Zoom when you conducted this evaluation?
How long was I? Say again?
How long were you on Zoom when you conducted this evaluation of Ms. Sahm?
How long did the time I conducted the evaluation? I can't tell you. It's over a year ago.
When you testified on direct that you didn't ask Ms. Sahm if she remembered receiving copies of the petition, is that true or is that report true?
I didn't hear the question completely, but I have a copy of the petition, if that's what you're asking.
But you testified that you did not ask Ms. Sahm if she remembered receiving copies of the petition.
If I didn't ask who?
Mrs. Sahm,
Oh, I hear what you're saying. Yeah, she did. She apparently did not remember, right?
Why is your testimony inconsistent with your report?
I don't think it's inconsistent. If you point out the inconsistency to me, I'll try to clarify it for you.
On direct, you testified that you did not ask her about receiving the petition. However, in your report, you state that she doesn't remember receiving the petition, which statement is true.
I stated what?
Let's go, I'm going to move on. Let's go to page 2 of your report, sir.
Which report are we looking at, 23 or 24?
23.
May? The May report?
Yes.
Okay, what do you want to know?
Page, can you please look at page 2, look at 4.0?
Page 2, yeah, 4.0?
Yes.
Right.
Isn't it true that your recommended course of treatment was that the AIP is in good physical health and she can continue to live independently?
That's what I wrote.
Where in this report does it say she has Alzheimer's or severe mental cognitive issues?
I'd have to look at the report, whether it says it or not, but that's indeed what she has.
Is that based on your May or your second report that wasn't used in court?
Say again, please.
I'll move on. Can you please look at point 5.0, functional assessment on your report? It's on page 2.
You're saying you're talking about item 3? Is that what you're asking me about?
Item 5.0, functional assessment.
Yeah, okay, go ahead.
Are you aware of Florida statute 744-102 that discusses what determines whether AIP is incapacitated or not?
I couldn't cite it. I couldn't review or state what that says specifically. If you want to read it to me, I will tell you whether I'm aware of it or not.
Okay, are you aware?
Based on the question and answer.
Are you aware that to find someone incapacitated, you need to consider their health care of themselves, their ability to feed themselves, their appearance, and their ability to clothe themselves?
I've did over 1,000 evaluations. I'm quite aware of the requirements that that you need to determine whether a person is incapacitated. And based on the evaluation I did, I rendered an opinion that indeed she is incapacitated.
So let's look at section 5.0. Isn't it true that you found that she can shop alone for clothing and food? You have a Y next to it.
That's a typo. There's no. It's Y no. The Y is a typo.
Isn't it true, in the next line, you said that she, Mrs. Sahm, can prepare her own meals, correct?
I have to look at the report because I certainly don't remember.
Look at page 2, 5.0, functional assessment.
Yes. Yeah. Yes, she can prepare her own meals.
And if you go to the next page,
Yes.
it's the fifth one down. Isn't it true you found that Miss Sahm could take care of her own personal appearance?
Yes.
And isn't it true you found Miss Sahm could socialize with her friends?
Yes.
Isn't it also true that Florida has denied you receiving your license to be a doctor here since 1984?
The court has denied me.
The
What?
Florida Department of Health, where doctors are licensed in this state, you have been rejected to be a doctor in this state since 1984. Isn't that true?
No.
You applied to be a doctor in Florida and you were denied, correct?
Did I what?
You applied to be a licensed physician, what, a gynecologist, I think, in
I'm not a
Florida?
gynecologist. I'm not a gynecologist. I'm a urologist. And I did not apply for a license in the state of Florida.
Ever?
Ever.
Are you aware that I did a 119 request for your application here and with the Department of Florida? There's proof that you were denied being a doctor in the state?
Am I aware of the allegation? No, I'm not aware of the allegation.
Are you aware that when... Are you aware that there's a relationship, a legal relationship between the other two committee members, Dr. Stephanie Cheshire and Brennan Cheshire, and that's against the laws for committee members?
To sustain the.
I have no knowledge of what the rules are, nor is it relevant to what I do.
But I'll allow his answer to stand.
You testified on direct that you gave testimony in front of Judge Burton in relation to
Yeah,
this.
I believe I did. I believe I did, yeah, but my memory is vague on it.
Isn't it true that you actually did not testify in Judge Burton?
It's quite possible. It's quite possible. All of this happened over a year ago, and I'm not sure of times and dates and who I testified in front of and who I didn't testify in front of. So it's possible I'm incorrect. I don't know.
So, you Your last statement wasn't true then?
Same answer.
Over.
Isn't it true that a MOCA score of 18 out of 30 only signifies a mild cognitive impairment?
Mild to moderate, and it's only one part of the diagnosis. There are multiple factors that you consider when making the diagnosis, one of which is the MOCA test.
Isn't it true that to have a moderate cognitive impairment, the score must be between 10 and 17, not 18 or above?
I beg your pardon?
Isn't it true that according to the MOCA test, that to have a moderate cognitive impairment, the score must be between 10 and 17?
There's a cutoff point at 17 and 18. It's moot.
Where is that in the MOCA testing?
I'm giving you my
protocols?
opinion. My report is based on my opinion.
And your opinion was based partially on this MOCA test, correct?
My opinion is based on my evaluation, the report of the neurologist, my conference with my other members of the examining committee, the medical information that's available to me, the interviews that I carry out if I carry out any with a family member. It is not based on a MOCA test.
There's nothing in your report that refers to you reviewing any medical records, sir.
There's nothing in my report, what?
There's nothing in your report that refers to you reviewing medical records. Is your testimony here today now that you reviewed medical records to make a decision? You're saying outside medical records?
When medical records are available, I review them. The medical record that I have is a record from the Neurological Disorders Clinic by a neurologist who found that Patricia Sahm has Alzheimer's disease, is unable to make any decisions about where she will reside, lacks proper character judgment, cannot decipher genuine relationships from scams or tricks. She is not able to determine who is safe to socialize with. As a result, she is unable to handle her own financial affairs or any legal contracting. If you have any questions, you can call the office. That is the report from Fernando Nerono, neurologist.
Date, please.
June 26, 2024.
Okay, June 26, 2024. You're relying on a report that's a year and 2 months after this to make your findings, sir?
As I said before, I don't rely on any one thing. I rely on all the information available to me plus my own evaluation.
Which was observed for a time you don't remember. A month of time you don't even remember.
Say again?
I'll withdraw that question, Your Honor. Did you read Dr. Sugar's report?
Did I read whose report?
Dr. Sugar, who gave an opinion for the AIP's attorney?
I don't have
his
that.
report?
I don't have that in front of me right now.
But have you read it?
I don't recall reading it.
Are you sure?
I don't recall reading it.
Well, you keep talking about a second report you did. Isn't it true that the 3 committee members were removed in 2024?
Isn't it true what?
He's testified to it.
Although it would be helpful in my case, it's not helpful.
Overall.
You referred to the fact that you did a second report in 2024, correct?
There was, I'm sorry, I didn't hear you.
You referred to the fact that you did a second report in 2024, correct?
I evaluated her twice, correct.
Overruled.
And isn't it true that that was not used by the court and the court appointed 3 new committee members?
Isn't it true what?
That those reports were not used in 2024 and the court appointed 3 new committee members?
You're breaking up something about 2024 and 2023.
Is it true that after you wrote the report in 2024 that they were not used because the court appointed 3 new independent committee members?
I'm not aware of that. That's possible.
In a moment, Your Honor. Sure. One second, Your Honor. No other question. I have no other questions of this witness, Your Honor.
All right. Any redirect examination, Mr. Sweetapple?
This witness, however, I am going to ask for leave to call Ms. Lewis for 2 minutes as to why parties stipulated to.
May I dismiss Dr. Bloom?
Yes, I'm finished with Dr. Bloom.
All right, thank you very much, Dr. Bloom. You can log off the Zoom.
Thank you, Dr. Bloom.
Thank you. Am I dismissed?
Yes.
Thank you very much.
Thank you.
I'd like to, if I could, Your Honor, briefly call Attorney Lewis just with regard to what happened with regard to the 2024 panel, since there's an attempt to create some impression that he was disqualified some.
All right. Is she on the witness list?
No.
No, but this is by way of rebuttal.
All right. Why don't we?
I object, Your Honor. There's prejudice, and he could have reasonably understood that when he was calling this witness, that there would be issues as to the admissibility or lack of admissibility, testimony, or use of these reports.
But his reports are not in evidence.
And 2024 was not relevant time period.
And the decision that I have to make is not whether or not she qualifies as an incapacitated person. I have to, we're getting way far afield, but you know what? I'll let you call Ms. Lewis, I'll let you cross-examine her, and I'll take the evidence for what it's worth, which may not be germane to the court's conclusion, but come on up, Ms. Lewis.
I don't think it is relevant to the court's conclusion. However, I think there's been a misimpression created.
Would you raise your right hand?
The evidence you're about to give will be the truth, the whole truth, and nothing but the truth. Thank you.
All right, watch your pep on your way up. Mr. Sweetapple, whenever you and Ms. Lewis are ready, you may inquire.
Thank you, Your Honor. Would you please state your name?
Yes, my name is KATHRYN Lewis.
And how are you employed?
I am a partner at Kitroser, Lewis & Dingle.
And are you a licensed Florida attorney?
Yes, I am.
How long have you been so licensed?
Since 2008.
And are you counsel for Charles Rivard, the guardian of Ms. Sahm?
I am.
And were you involved with regard to evaluations of Ms. Sahm again in 2024 after the 2023 that are the subject of this controversy?
In 2024, myself and Mr. Kitroser were representing Mr. Rivard at the time that those evaluations were performed. We did not personally have any involvement in the actual evaluation.
And did counsel for anyone request that there be a reevaluation in 2024?
Yes, we filed a petition to determine incapacity and a petition to expand the guardian's powers in order to give the guardian control or ability to make decisions regarding Mrs. Sahm's residence and social environment, which were 2 rights that were not removed in 2023.
And did the court grant that expansion?
Yes.
Right. And was there a new examination committee appointed?
Originally, after we filed the petition to determine incapacity in 2024, the court reappointed the committee from 2023 to evaluate Mrs. Sahm again.
And what happened?
They did their evaluations, they filed their reports. Thereafter, attorney Laura Burkhalter, who had been court appointed to represent Mrs. Sahm in the 2024 incapacity proceedings, filed a written objection to those committee reports. And as part of the grounds for her objections, she stated that because this was the original committee from 2023 that had previously found Mrs. Sahm incapacitated, that it was an infringement on Mrs. Sam's presumption of capacity.
And was a new committee appointed?
Yes, we actually agreed, Mr. Kitroser and I, on behalf of Mr. Rivard, we agreed to the appointment of a new committee to remove that from being.
And that committee, did it also determine that she was incapacitated?
I think it's relevance.
And did they recommend an expansion of?
Sustain.
No further questions, Your Honor.
Any cross-examination with respect to?
Were you the attorney in May of 2023 in the guardianship and mental health case?
No. I personally was not involved in the case in May of 2023. I'm not sure whether or not Mr. Kitroser had been retained by Mr. Rivard at that point in time. Personally, I'm not sure.
Isn't it true that your law firm and Mr. Rivard were even brought into this case until June of 2023 by agreement?
I don't.
Of Ms. Patwell.
I don't know what standing Ms. Patwell would have to agree as to whether or not Mr. Rivard retained my law firm.
So you don't know if there was actually testimony given to Judge Burton, do you? In May of 2023 or June of 2023?
Personally, I don't know. I believe there was an agreement among the parties. Ms. Patwell withdrew her objection to the committee reports. You, on behalf of the Bernsteins, did not pursue an objection, from what I understand. And because there was an agreement, the court entered an order adjudicating Ms. Sahm incapacitated.
Isn't it true that the order doesn't actually have a date of adjudication or determination of the incapacity? It's a blank.
How is it? Wouldn't the order be the best evidence?
I'm sorry?
Wouldn't the order be the best evidence?
Well, since there's a lot of issues here going to the mental impressions of the capacity, non-capacity, and the ability to enter into contracts at that time, I think it's very relevant that there was no due process finding of incapacity by the court. I guess that question.
I guess I don't see how, with all due respect to Ms. Lewis's knowledge of the date, whether or not the order contained the date is relevant to the issues that we're here to decide. So I'm sustaining the objection as to the best evidence. If you want to provide the order and show me whether or not it has a date, I can read it.
I'll do that because it's an evidence. Okay, thank you.
All right. Thank you. Any redirect examination? All right. Yes, ma'am. You may step down. Any additional witnesses or evidence on behalf of the claim?
Just on the party deposition.
All right.
Good. Easily. And I don't think we have copies. Transcript, I think online.
No. Hold on, Your Honor. I object fully. You cannot just use a depo. This is improper impeachment. You want to use a deposition for a witness, you can use it if you find that the witness is dead, which he's not. He's greater than 100 miles, which he's not. He's out of state, which he's not. And it doesn't appear that he's absent. He never gave proper notice prior to the trial of using a deposition. You can't use a deposition to impeach a witness when he's not here and he's available. He could have been subpoenaed. So I believe it violates Rule 1.330. And basically, he cannot use the deposition under 1.1330A. And he hasn't given a proper notice. It's a due process hurdle he has to overcome. And I can cite all the case law if you'd like, Judge.
Sure. Cite me a case that says that you can't use deposition of a party opponent.
As the way he wants to use it when the party's available and he didn't subpoena him. He can't come in here now just read a deposition without proper notice.
Okay. Cite me a case that said.
They said that basically, let me see. Okay, the 4th District has a case that says that the rule.
What's the name of the
Let me see.
What's the citation?
I'm going to give you, hold on 1 second. First of all, there's a hearsay hurdle to overcome under Rule 1.330. And basically, they said that under Dinter versus Brewer, 420 Southern 2nd, 932, Florida 3rd DCA 1982, the court found that hearsay was inadmissible because it didn't satisfy the provisions of the former testimony rule. In other words, the rule itself is only exceptions to the hearsay rule.
Isn't prior sworn testimony of a party opponent taken at a deposition subject to cross-examination specifically an exception to the hearsay rule?
Cross-examination, Your Honor, but
subject to cross-examination, not
I
cross-examination.
believe the rules, Your Honor, allow the opposing party's deposition to be used at any time for any purpose. That's been my use of them for over 40 years, and I've never had anybody say I couldn't do that. So I'm ready to be corrected if I'm wrong.
I believe it's a due process violation to allow him to use a rule against a party who has not testified, who he's not subpoenaed, he's not called as a witness, and he's coming in here using a deposition without proper notice. The rule does say you have to give me notice and a copy of the deposition. My client never, and it's also he has to be unavailable if he wants to use a deposition, or he would use it on proper cross-examination. You can't use a deposition as direct testimony. Not the way he wants to use it. It's not following the proper rules.
Mr. Bernstein was here at our last setting, and I have deposed him and intended to cross-examine him. He's not here today, and I believe I'm entitled to use his testimony from the deposition as a party opponent for any purpose at any time. She can call him if she chooses to. He's a party.
Rule 1.330. A, use of depositions. Upon any hearing of a motion, any part or all of deposition may be used against any party who was present or represented at the taking of the deposition, or who had reasonable notice of it, so far as admissible under the rules of evidence applied through the witnesses or then present and testifying in accordance with any of the following provisions. Subsection 2 is deposition of a party or of anyone who is a person or agent designated may be used by an adverse party for any purpose. So I'm overruling your objection.
It also, Your Honor, in A1 does discuss the fact that if you want to use it for the purpose of contradicting or impeaching any testimony of a deponent as a witness, you do have to follow the evidence code, and you do have to give proper notice. You can't just come into the court with a deposition that hasn't even been read.
When was this deposition taken?
This deposition was taken October 2nd, 2020.
All right. And was it listed as a potential exhibit or item of evidence?
No, Your Honor.
We took this after all that occurred. It took us forever to get Mr. Bernstein into the deposition, if you recall.
All right. When did you determine that you were going to use your deposition?
I was going to use it for cross-examination today. However, I noted that for some reason, Mr. Bernstein, who sat next to her the entire proceeding in August, is not here. So
Is Mr. Bernstein present on Zoom? If so, can you unmute yourself? Deputy, could you sound the hall for Mr. Bernstein? All right, deputies indicated that Mr. Bernstein is not present, so I find that he's not availed himself to be cross-examined here in court, so it would not be fair to the other party to not allow that portion of his testimony to not be provided to the court. I'm overruling your objection.
Your Honor, if I may, I'm reading from page 76, starting at line 4. Question, and how many times did you meet with her before the guardianship was filed? Answer, probably most of the times. Question, well, after the guardianship was filed, did you still meet with her and try to get her to sign a settlement? Answer, I have to look at my notes and figure that out, but. Question, didn't you appear at her house on more than one occasion before she signed the settlement agreement to meet with her? Answer, I did. Question, okay, and you had the settlement agreement in your hand when you met with her, right? Answer, I did. Question, this is at page 77, line 3. Didn't you, so you met with Mrs. Sahm after the guardianship had been filed, right at her house? Answer, yes. Question, on more than one occasion, correct? Answer, yeah, most likely. Then on page 88 at line 2, okay, so you were helping Patricia Sahm Sr. find an attorney? Answer, yeah. Question, okay, and you asked everybody in the guardianship abuse group who you could get to represent Patricia Sahm Sr.? Answer, correct. At line 89, page 89, line 13. And so how did you learn that Miss Patwell had been hired after you recommended that someone go find an attorney for Mrs. Sahm? Answer, how did I learn? I think through Patty Jr. or something. That's all I'm reading you.
All right. Is there any portion of the deposition that you would like for me to consider according to the rule of completeness, Ms. Garcia?
Your Honor, I would need time. I will do that before the close of my case.
Okay. All right. Is there any additional witnesses or evidence?
Your Honor, I have no further evidence with regard to our motion.
All right. And then motion on behalf of, let me turn to Ms. Garcia first for your motion, understanding that you had entered evidence, but we just did that for expediency's sake. This is now the close of the plaintiff's presentation.
Plaintiff is arrested?
Yes, ma'am.
Okay, Your Honor, I'm moving for a directed verdict pursuant to Rule 1.480. The plaintiff has closed his case, and the plaintiff has not proved the necessary elements of the case. Firstly, excuse me, Your Honor, the plaintiff has not proved by clear and convincing evidence that Ms. Sahm was incapacitated in May of 2023. The witness had testified, was not forthcoming as far as remembering what happened, misrepresenting to the court the cognitive based on the MOCA test, misrepresented that he testified in front of Judge Burton, which didn't happen. There's testimony by Miss Lewis. She wasn't involved in a case at the time, so nobody could confirm that there was any ever actually hearing or determination by Judge Burton that the client was incompetent. Also, Ms. Sahm did not have her due process or her right to contract taken away by the court at the time the settlement was entered into. The evidence that is in evidence, his evidence, is that the settlement was entered into on May 22nd, and there was no finding of incompetency by the court, by any court order, or by any due process hearing until June, by agreement of the parties for limited guardianship for Charlie Brevard, who's her cousin. At the time, there's no proof that at the time that the settlement was issued, that there was any nefarious conduct by either myself or Ms. Patwell or the other attorneys, Morgan Weinstein. They're simply put that the plaintiff has not carried their burden for this court to determine, first of all, if there was any competency or not at the time. Further, they haven't proved, pursuant to the law, that, or rebutted by clear and convincing evidence, like Harmon versus William, 596, Southern 2nd, 1139, a Florida 2nd DCA case. It says the court holds that a person is presumed competent to contract unless incompetency is established by due process of the law. So this court basically would have to make a proactive finding that prior to any adjudication that you're going to take away, retrospectively, a client's right to contract with a lawyer. It's clear that she had a lawyer, Amber Patwell, who was assigned and accepted by the court, and that there was a settlement that was entered into. They waited 14 months to try to set it aside. Then they tried to come in with allegations of the exception to the rules. So the court determines by clear and convincing evidence, he believes that the client, they did not prove incompetency sufficient for you to prospectively negate a legitimate contract that the guardianship court didn't negate, and nobody had even fought for a year. Then you have to get to the next level of the argument, which would be that there had to be some undue influence or some fraud. None of that has been proven as far as this settlement that was entered into, that was validly entered into with her having an attorney present. And the evidence that is in the other committee report that is in evidence, Your Honor, does say that she can contract with the help of an attorney, which she did. So there's nothing that has been proven here in his case in chief that would give Your Honor the ability to take away her presumed competency to contract. And there's nothing in the evidence so far that would prove any fraudulent activities or undue influence related to the execution and timing of the contract. In fact, the evidence that was presented through the court orders and the dates and times show that as soon as Weinstein was hired April 12th, and then there was no stipulation done and no settlements were negotiated. Mr. Weinstein had nothing to do with it at that point. The evidence shows that in May, there was a hearing in the bankruptcy court wherein the attorney, the retainers in evidence, represented the estate that has no rights. At one point, a dead man who they never told the court was dead. And then Ms. Sahm, that according to Mr. Sweetapple's testimony at the last hearing, or his proffers, were that she was incompetent. He was traveling under a power of attorney. But in the meanwhile, they're still moving forward, hiring lawyers and filing defenses that are not legally proper. Filing a claim in a federal bankruptcy court for a state that you've admitted has no rights is a fraud on the court. Filing claims for dead people for years, including the affidavits or evidence for dead people, is improper. So I don't believe that he's met his burden, according to the law, for either the declaration of an incompetency and or fraud or undue influence to set aside the agreement. So those are some of the specific reasons, Your Honor. You have in evidence basically that we would ask the settlement to stand as is, because the plaintiff has clearly not proven his case.
Mr. Sweetapple.
May it please the court. The evidence in this case is clear that the Bernsteins knew at all times that Ms. Sahm had declined into incapacity, and of that there can be no doubt. Ms. Garcia knew the same thing because, as you noted, she tried not to put in the signed settlement agreement that she forwarded to Mr. Raymond and in March of 2024. And that agreement prepared by her and signed by all of her clients, repeatedly recites that Mrs. Sahm Sr. is incapacitated. And I'll read to you some of those quotes. I have my highlighted copy be quicker than me looking at the unhighlighted copy, but
Page 2 of plaintiff's 12, whereas Walter Sahm Jr. is now deceased and his estate is pending in Marion County, and his now incapacitated wife, Patricia Sahm, has a power of attorney, trust, pre-need guardian with her daughter, JOANNA Sahm, whereas the estate trusts and the incapacitated surviving spouse.
Exactly.
Page 3.
Right. This is an admission of their knowledge of her incapacity, that they signed this in March. It's a admission of Ms. Garcia's knowledge of her incapacity. And yet, what do we see? We see Patty Sahm Jr., the same person Judge Burton found was taking advantage of her mother and allowing a signature or a notarization of a revocation of a power of attorney to occur using the Bernstein's agent. Mr. Bernstein admits he's helping through Patty Jr. to get an attorney for his opponent, Mrs. Sahm. There's always the suggestion throughout this case, including my cross-examination of Ms. Inger, that somehow I was substituted in this case. But Patty worked with Mr. Weinstein. You can see through the communications, had Mr. Weinstein come in, a friend of Mr. Hall's, to try to take over so they can backdoor a settlement taking advantage of Mrs. Sahm Sr.
That's not evidence.
So Mr. Weinstein lasts a few days. He never sends me a stipulation for substitution of counsel. I've represented Mr. and Mrs. Sahm since the beginning in this case. I represented Mrs. Sahm individually, and then when her daughter told me she had a power of attorney and Mrs. Sahm told me she had a power of attorney, I additionally was authorized to deal with JOANNA Sahm. But the bottom line is, they knew that I was the attorney in this case, and all of this is occurring without any attempt to have me join in on either of these settlements. And you're going to see if, and this is not appropriate this time, but you're going to see I was not copied at my email address with communications that have been represented that I didn't respond to. So what happens? Well, this fraud that's occurring involving Patty, Inger Garcia, and the Bernsteins, and Miss Patwell, who's brought in by the Bernsteins, is just a continuation of a fraud that the bankruptcy court already occurred by Miss Garcia in the state court. And 3 days before the guardianship's filed, the federal court grants in rem relief from an automatic stay that Ms. Garcia obtained. And if you look at paragraph D, attached to the motion as Exhibit D is a copy of the suggestion of bankruptcy for defendant and notice to cancel sale set for April 4, 2023, parenthetically, the suggestion of bankruptcy, filed on April 3 by attorney Inger Garcia on behalf of certain defendants, including debtor Eliot Ivan Bernstein in the state court case. The suggestion of bankruptcy is factually false and legally incorrect and was designed to mislead the state court and or the clerk of the state court into canceling the April 4, 2023 foreclosure sale of the real property scheduled in the state court because the suggestion of bankruptcy stated that, quote, this action is founded on a claim from which a discharge would be a release and that seeks to impose a charge on the property of the estate. This is the second fraudulent bankruptcy. The first one, the sons are all assessed $43,000. This is the second fraudulent bankruptcy. But Ms. Garcia is representing the Bernsteins. They're fully aware of the guardianship, as is she, because watching all of this occurring, the first thing I do when I hear for the first time that there's been some alleged revocation of a power of attorney, which would not have in any way affected my direct representation, Mrs. Sahm, who was my client and always competent the entire time I knew her. But I'm dealing now with JOANNA for the last couple of years at Mrs. Sahm's direction. So when I call Mrs. Sahm, and I put this in a notice so that all counsel would be alerted that we're watching you, don't continue with your fraudulent conduct. What do I do in my request for judicial notice? 1, plaintiff is a surviving spouse and owner of the note, which was the subject of the instant matter. 2, undersigned counsel has been advised that a revocation of the current power of attorney held by Mrs. Sahm's daughter, JOANNA Sahm, has recently been executed. 3, undersigned counsel spoke directly with plaintiff Patricia Sahm yesterday. Mrs. Sahm indicated she was unaware of any such revocation and still wanted undersigned counsel to represent her in this matter. 4, the court is further advised and requested to take judicial notice of the pending guardianship matter, and I cite them. So while on May 5th, all 3 committee members find that she's unable to manage her litigation, and Miss Adwell is not counsel of record. There are attempts by documents prepared by Mrs. Garcia, Mr. Bernstein's going to the alleged incapacitated person's house, and on the 22nd of May, obtains her signature when no one else is there.
Objection, facts not in evidence.
So, I don't mean to cut you off, but this is a motion for directed verdict.
And so what I'm going to show is the evidence in this case.
I draw all inferences and conclusions in the light most favorable to the non-moving party.
Exactly. And this is a motion. This isn't a properly directed verdict application anyway. It's not a trial. You need to hear the entire case, but when I got to the end of the case, what I'm going to show you is...
you rested your case.
Yeah, but I'm saying when you hear her case, there's going to be more coming out that's going to implicate them in the fraud and the sanctions.
So I find, based on what I've heard so far, in the light most favorable to the non-moving party, a reasonable fact finder could find that you've established your claim, and I'm going to respectfully deny the motion for directed verdict. So let me turn now to Ms. Garcia to call any witnesses or evidence that she would like to produce.
Sorry, Your Honor. I thought you said after this witness that you were calling a lunch break.
I would like to get this case concluded today. We've really spent a lot of time. So you have a witness, I think that's on Zoom. I can give you a short break, but we're going to conclude today. So you have Mr. Stansbury, I think you said you were going to call, and who else?
I have myself.
And yourself?
And potentially Ms. Bernstein.
Okay.
And now that he's done that to Mr. Bernstein, I have to see if I can find him.
He's done what, Mr. Bernstein?
Now that he read his deposition testimony with no proper notice.
Okay. When we took a 10-minute break, you said you had perhaps one witness, Mr. Stansbury, who's on Zoom. Now you're telling me you have 4 witnesses.
Well, I'm testifying, definitely.
Okay. All right, what we'll do is, Madam Court Reporter and Madam Clerk, how long do you all need for? You're in charge. 30 minutes? 10? Madam Court Reporter? All right. Why don't we'll take 20 minutes. There's snacks downstairs, I think. There's restrooms. Pick back up. All right, looks like everybody's present. So let me turn to Ms. Garcia. Who's your first witness?
Your Honor, what I'd like to do under the rule of completeness, I'd like to move in the entire deposition of Mr. Bernstein. I have a copy provided to counsel, but they need to make a copy. We still have an extra one.
Okay. Do you have any legal objection?
You, please, the portion that's object to putting in the client's testimony, opposing party to this, not a party. He needs to call him.
The rule of completeness allows, if you publish a portion, for them, if they wish, to publish the portions that provide context. So what additional portions that provide context are you seeking to admit?
The entire deposition goes into the whole theory of him supposedly manipulating and being involved to an excess of undue burden. And if you read the deposition in of itself in its completeness, you'll see that that's not true. You'll see what his actual testimony is, not just portions. And the document, the doctrine of completeness allows, if one party introduces in trial, the adverse party may require the introduction of the other parts of any other writing or recorded statements which ought in fairness be considered. And it ensures that the judge or the jury, the finder of fact, gets to view the incomplete statement in its full context. So you'd have to hear his deposition to have the proper full context of his testimony. It's also an explanatory evidence rule. And it allows otherwise inadmissible hearsay to be admissible under the rule, correct any confusion or wrong impression created by the admission of the original evidence.
That's the law. I read 8 portions showing that Mr. Bernstein was involved with the repeatedly had a settlement, and that he was involved in stealing her counsel, Ms. Pat. Anything that she wants to read or introduce that in any way deals with those topics, I have no objection. She clearly has a right. If she has somewhere where someone can show that. By all means, but the idea that you can read 80 pages.
Well, I don't think she's going to read it. I think she's going to submit it to the court to allow.
Yeah, but I don't think that's permissible.
It is one Federal Rule 109.
That's not the rule of completeness. The rule of
completeness deals with what I just said.
It would deal with an otherwise inadmissible hearsay statement, such as her offering her own client's statement if it needs to be provided to give context.
It promotes the transparency since only one part of the statement was shown. It prevents you from having a biased view of the entire situation. It allows a level playing field. It ensures both sides have an equal opportunity to present their case.
Over the plaintiff's objection, I will receive it as what we have. Defense exhibit number 27.
The entire transcript?
The entire transcript as according to the rule of completeness. 90.108.
Mike's not in the time.
So I can provide one to the court.
And
I don't have a certified copy.
You can print out a copy. Right?
if you email it to me, I can get it printed out. If you email it to the CAD.
So I have Procedural question, Your Honor. Since I plan on testifying and I need to refer to the different exhibits while I'm testifying to either refresh my recollection or to talk about my mental process, do I sit in the witness stand with my exhibits or? Because I'm not sure, or do I sit at the table or stand here?
It may be easier for you to sit at the table as long as you're by a microphone so that we can pick you up. Because I'm not going to be able to, I'll probably be able to see you at the table better than I can see you up.
Right. I could stand here too if you'd like, Your Honor. It's up to you.
You could be seated so you can go through your.
Okay, so I call my first witness myself, Your Honor.
All right. Would you raise your right hand? You swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, you can put your hand down now. Go ahead, Ms. Garcia.
Good afternoon.
Good afternoon.
My name is Inger Garcia. I've been an attorney since 1991 in Georgia. In Florida, I was licensed in 97. However, in 1989, I worked under Judge Kastrodakis at the prosecutor's office for Janet Reno in an internship and for chief judges. I've been litigating since the late 80s. I am aware of the rules and the procedures in court, as well as testimony, impeachment, and honesty and integrity to the court.
At some point, did she ask her question herself and answered itself and think actually relevant evidence? Or just interrupt and object if it's relevant?
I think asking her to ask herself questions it's not going to work. So yes, just interrupt if you believe that she's providing testimony that is not permissible under the evidence code.
Okay, Your Honor. This is a case of a fairly long-term foreclosure between the Sahms and the Bernsteins and BFR, the company. I came into this case in January of 2023 to file a motion, a 1.540 motion, and a motion to continue a sale. Prior to that, there had been a bankruptcy filed by BFR, involuntary bankruptcy filed in Palm Beach County. You have the retainer agreement from Mr. Schreiberg in evidence, Your Honor, as Defense Exhibit 13. I attended those court hearings. First of all, I analyzed this case and determined very quickly, doing many, many foreclosure cases, because I've done a lot of foreclosure litigation over the years in real estate. I've been involved in real estate since I'm 18 years old. Worked for John Ritter as a real estate attorney back in the late 80s. I'm very familiar with foreclosures and the requirements and a proper protocol for a plaintiff to get a final judgment. I'm also fully aware of when someone dies, you have
So a witness, no matter how qualified or skilled, is not able to testify as to legal conclusions. That's for me to decide.
Okay, so I'm here to testify to my mental impressions that I've gained as a litigator in this case by observing the bankruptcy in the initial involuntary bankruptcy over the summer of 2022 and over the course of representing the Bernsteins in the foreclosure case. And then subsequently, as of August 2023, representing Patty Sahm Jr. based on an injunction that was filed against her in the mental health and guardianship cases. So I've been able to have, and then I also was at the hearing in April or May, no, April of 2023, where Mr. Bernstein had filed individual bankruptcy. And I was at that hearing. So I've been able to observe by analyzing all the cases as a united. There's a trust case, Your Honor, also where the funds are being held. $277,000 has been held to pay this settlement, to pay for this foreclosure. There's a court order. That money's been available.
She's testifying. She's providing evidence, right?
Yes.
Oh,
I'm testifying from my knowledge and opinion as the attorney. I can move the court order in, Your Honor, from that case. We can do judicial notice. The Shirley Bernstein trust case, I can give the citations. I'd be happy to do.
right.
There's the court order reserving funds. The court order specifically states that the funds that are in the trust, the court registry, are to be used to satisfy the mortgage.
Okay. And do you have a copy of that order?
I don't, but I can pull it off the docket, Your Honor, and do judicial notice.
Are you objecting to the judicial notice of the order?
I'd like to see it. I'm not involved. I mean,
Okay. I'm overruling the objection.
Actually, Mr. Sweetapple is involved in that case because he filed a motion recently to release those funds for other purposes. For the purposes. So he is aware of the case and he is aware of the court order. And there have been emails back and forth. But by looking at the overall picture, Your Honor, what I gleaned, my knowledge, is that when I came into this foreclosure case in January of 2023, I saw massive, massive legal, technical, and fraud issues on the court. I brought it up to Judge Bell, who came in. KATHRYN resigned, I believe, like the day before the hearing. So Judge Bell came in for a short time frame, continued the hearing, continued the sale from January 2023 to April of 2023. And then at that point, then BFR filed, it was an involuntary bankruptcy filed. When it got converted to Chapter 7, the clients couldn't afford an attorney, so they just let it get dismissed, and then sanctions were moved for. But in that court, again, I determined by looking at the retainer that's in evidence and looking at the notice of appearance that was filed by Mr. Schreiberg for a dead man, and I brought it up to the federal court and said, Judge, they're filing still for Walter Sahm, who's dead, and you have his birth certificate, his death certificate in the record, stipulated to as exhibit
I'll stipulate it's in the record.
I think it was 7 or 8.
He died in 2021. I believe January 2021. And after Mr. Sahm passed away, there was no substitution of counsel of the estate. And also in evidence is proof that the estate, when they did their notice of inventory, they did not list this.
I guess the problem that I'm having is I don't understand why, if we keep wanting to talk about the 1.540 motion, we haven't done both of them at the same time.
Your Honor, I think we do. All due respect, we're going to notice this was never noticed one motion. Never moved to settlement. You've never said anything because your full conduct is critical.
Okay, but that's not a legal objection to her testimony right now. My question is, how is the 1.540 issues relevant?
I'm not.
No, but how is it relevant to what we're here for?
It's relevant to here because I believe that when they're accusing me and Mrs. Patwell and my clients of fraud on the court, there's a reason this case was settled. and I'm trying to explain the mental process and the reason legally of why observing the different inconsistent behaviors and inconsistent filings in court orders that are not accurate, that are inconsistent with transcripts and findings.
I asked the question, so I'd like, she's answering my question.
It's relevant to the issue of this. What is the fairness to Patricia Sahm for settling a case for an amount less than a final judgment? And to make a decision in settlement, what you do is you look at the facts of the case and you look at the potential defenses and the costs and the expenses. And you look at what is pending and what has happened where, so you know. So I'm trying to explain to the court my mental process, and what I see is the reason this case was settled. So the court understands this wasn't a rush to go settle a case for an amount that wasn't fair and reasonable and understandable based on the affidavits of summary judgment, based on the final judgment, based on the pending pleadings, based on the different frauds that I can explain to the court.
But how is your intent as to why you wanted to settle the case relevant to the issue of whether or not the settlement agreement should stand?
One of the factors to determine if you're going to set aside a settlement, you have to find by clear and convincing evidence there was undue influence or fraud. So I'm explaining to the court why there was no undue influence or fraud by the facts of the case, and explaining to the court that the actual behavior of Ms. Sahm's attorneys, the different attorneys in the different courts with the inconsistent misrepresentations, is one of the reasons why this case was settled by Ms. Patwell and I, is that we saw the risk as far as the damage and the costs and expenses, and it wasn't worth it to either client to not resolve it how they resolved it.
Are you trying to testify as to why Ms. Patwell decided to settle the case?
I could tell you based on my conversations with her of why we both agreed that this was a fair and reasonable settlement and it was proper.
So how's that not hearsay, I guess?
Because I'm testifying to my mental impressions of based on conversations.
We're in a loop. I understand that the defendants want to settle the case. Obviously, the defendants want to settle the case. But the issue really for the court is whether or not the settlement agreement that the plaintiff, Ms. Sahm, ended up signing with Ms. Patwell's assistance, with the defendant's assistance, whoever, whether or not there was undue influence, fraud, coercion, anything like that. How is your intent relevant to that?
I believe that the actions of Mrs. Patwell and I, and prior to her, Mr. Morgenstein, who was retained specifically to settle the case, independent of me and independent of anyone else, prior to any thought process of a guardianship appearing in April 13th, he was retained by Mrs. Sahm independent. I've never met Mr. Weinstein. He's not a friend of Kevin's. The representations are that we somehow or another brought in this attorney to nefariously settle a case. She independently found Mr. Weinstein, entered into an agreement with him on April 12th. And my testimony from personal knowledge and from reviewing the different documents and speaking to my clients is that he left quickly after Mr. Sweetapple would not cooperate with the substitution, and because a phone call was made to him claiming to be Ms. Sahm to terminate him when that's not who made the phone call. So he was run off, just like Ms. Patwell was run off.
What is your basis for that knowledge? Is it not hearsay? Were you there for the phone call? Did you hear the phone call?
I did not hear the phone call, but from speaking to Mr. Weinstein and speaking to
somebody told you
Amber.
Something out of court, and you want me to consider it for the truth of the matter asserted. That is hearsay.
Not necessarily, Your Honor. I want you to consider it to understand our frame of mind that we were attempting to do this in good faith. We weren't nefariously running to settle a case after guardianship was filed. There was prior settlement negotiations, which does go to the elements and the facts of the case.
So then why don't you focus on what role you have taken as opposed to what you've heard other people do, or what you believe Ms. Patwell wanted to do, or what conversations Ms. Patwell had with you, as opposed to things that are clearly hearsay.
Okay. The role I took was when I was informed that there was Mr. Weinstein was going to be the attorney, I contacted him and asked him if he was going to be jumping in as her attorney. And he said yes. And the day before the bankruptcy hearing, he couldn't come to the bankruptcy hearing to tell the bankruptcy court that Ms. Sahm had hired him to settle. So I told the bankruptcy court, as an officer of the court that day in April of 2023, that Mr. Weinstein had been hired and that the power of attorney of which the claim in his case was made was revoked. And I told the court, I said, and I had the transcript, and I told the court, I said, Judge, I don't believe that they know, Mr. Schreiber knows that the power of attorney was revoked, but he's traveling. If you look at his first retainer, that's in evidence. That was in 2022, where he said he represented the estate, which now we know has no rights, which I was misled the entire time about the estate having rights. That's why I negotiated with Mr. John Raymond for months, for the whole month of March. So they filed claims in the bankruptcy court based on a power of attorney that didn't exist and based on a claim for a party that doesn't have any rights, which they've admitted over and over again in this case. And in emails, that the estate of Walter Sahm never substituted in, the estate of Walter Sahm was never a creditor, but they're going into federal court and representing that the estate has rights and securing judgments against my clients and securing orders that are simply not based on truth.
There has never been a claim in this case that the state had any rights. The only ones that have been adjudicated have committed fraud in the bankruptcy court, were in the first instance, Bernstein children, and in the second instance, Ms. Garcia. So to sit here and delusionally respond to her view of what she did, in fact, she's involved in it. When did she learn that the committee had found universally that Mrs. Sahm was incompetent? And what did you do after that? Why didn't you contact me when I was counsel of record? Why didn't you miss a substitute?
Okay, we've gone beyond legal objection. I'm sustaining the objection. If you want to argue the case, you could argue the case. If you want to testify to facts that you want me to consider, subject to cross-examination, stick to the facts that you want me to consider.
So I will testify that, Your Honor, that in the month of March 2023, I was negotiating a settlement of this matter with John Raymond, who represents the estate and represents Joanne Sahm as the trustee. The trustee is the one that owns most of the assets and controls the assets. During that time frame, when we were negotiating, I was led to believe that the estate had rights and that Ms. Sahm was incapacitated because Joanne Sahm had testified in bankruptcy court in 2022 that she was representing her mom under a power of attorney under a pre-need guardian. Her mother had mild cognitive issues, and she had been asked by her dad to handle the financial affairs. So under the belief of filings in federal court by an estate that really had no rights, and by Patricia Sahm Sr., who had no idea that her daughter was signing her name on retainers and hiring lawyers in court, I began negotiating with the parties that appeared to be the correct parties, which was the estate and Patricia Sahm under a power of attorney. So at the time, I asked numerous questions, and it's in my email that's in evidence.
Can I ask a question? Wasn't Patricia Sahm represented by counsel? Why were you negotiating with her directly?
I wasn't. I was negotiating with John Raymond directly, but he represents, his law firm, Nelson Mullen, represents JOANNA Sahm. And JOANNA Sahm is the only person who really has been participating in this. Patricia Sahm has had nothing to do with the case.
But didn't Mr. Sweetapple represent Patricia Sahm throughout this proceeding, I'm not talking about the bankruptcy proceeding. Wasn't she representing Patricia Sahm? And then wasn't JOANNA Sahm in agreement with that representation?
He was representing Patricia Sahm through supposedly a power of attorney for JOANNA Sahm.
So that's kind of my question is why is it that why are you having communications with someone that is represented by counsel without communicating through counsel?
He was in, Mr. Sweetapple was included in some of the communications, and Mr. Raymond told me to send him the settlements and to negotiate there. And then he was answering my questions about who was the actual parties in interest. There was a confusion as to who the party in interest was, because they're telling the bankruptcy court the estate is a party in interest. Mr. Raymond is the estate attorney in the probate case. Okay. And then his law firm, Eileen O'Malley, also was Joanne's attorney who filed the guardianship petition 3 days after they found out that the mom had hired Mr. Morgenstein. So I went to Mr. Raymond and they asked me to send them proposed settlements. So we were going back and forth with the settlement and the language. And then as we were going through it, I was led to believe that Patricia Sahm was incapacitated, so JOANNA Sahm was the decision maker under the power of attorney, and the estate had rights because they filed a creditor's claim in bankruptcy court, which was at the time, I believe, pending. We were trying to resolve it with the attorneys who told me to resolve it with them. All these attorneys were working together in different courts. So at that point, we started drafting the language based on the representations that were made to them. But as I found out after 20 days and 20, 30 hours of drafting this, then I was told and I was informed that Ms. Sahm didn't need a guardian and she wasn't in a guardianship. Therefore, she is capacitated. So therefore, then I could settle it with her through her lawyer.
Yeah, right? Because then she would be represented directly by Mr. Sweetapple.
Through her lawyer. So what happened is there was a bankruptcy pending. So the case stopped. Mr. Sweetapple filed his notice on April 17th, right? Because between the time frame that I was told, March 31st, that we're not the right party, the estate has no rights, and Patricia Sahm doesn't need a guardian, and JOANNA has the power of attorney. Okay, so I'm told this by one attorney. I'm told different things by different attorneys. Mr. Raymond, who is the estate attorney with the most knowledge of the estate's rights.
Again, based on what she's saying, I'm looking at the email from Mr. Raymond to it says, this is March 30th. I read the note and see clearly what the note mortgage asked to provide by operation of law. Again, Mr. Sweetapple speaks with her. The estate has no say in that. And these series of emails are sent to me at rsweetapple@sweetapple.com, which is an email that doesn't exist. So she's told repeatedly by Mr. Raymond, contact Mr. Sweetapple. He's the one who's handling this. And yet there's no communication with me from Ms. Garcia or Ms. Peck. And all of these things she's talking about are orchestrated by Tony Jericho.
I'm not sure I object.
To caution her that this dialogue she's engaging may not be helpful to her.
So what happened, Your Honor, is from March 13th to March 30th, I was led to believe I was negotiating with the right parties. I was then told the estate has no rights.
Based on what? What led you to believe that? You introduced that email that Mr. Sweetapple is directing me to into evidence. That was the first email that we talked about where I had the highlighted copy of it. What about that leads you to believe that you shouldn't have talked to Mr. Sweetapple?
At this point in time, from March 13th to March 30th, I was led to believe and asked to negotiate with Mr. Raymond.
I hear you saying that.
Then what happened?
What led you to believe that?
The fact that Walter Sahm had passed, and that Mr. Schreiberg and JOANNA testified in the federal court, not once but twice, that the estate was the creditor and the estate owned this judgment. So therefore, if there's a bankruptcy and there's an estate involved, I'm allowed to negotiate with the bankruptcy attorney and the estate versus filing an adversary to see if we can get to some agreement at some point, which I understand at that point, had the bankruptcy not been pending, that point then, if it was done in March and we settled it in March, there were signature, that particular agreement, there were signature lines for all the different parties and cooperation language that if the estate has rights, we'll do it here. If we need the foreclosure rights, we'll do it here. So everybody was included. It was supposed to be a global settlement, Your Honor. It wasn't like we were going around the judgment.
But not the person that represented her in the case that you were trying to settle?
They were going to be part of the settlement, Your Honor. And he was copied on some of these emails, and he was included in some of these conversations, and he knew this was ongoing.
Okay.
So what happened at the end of March, well, we still have the bankruptcy pending, I believe, then come April 11th, Ms. Sahm decided she wanted to terminate Mr. Sweetapple and hire Mr. Sorry, I forget his name.
Your Honor.
Morgan Weinstein. Okay, nothing came of that.
Your Honor, Ms. Garcia has testified under oath that she has tremendous experience in foreclosures and notes. And it was obvious to her that this note passed by operation of law and was not an estate asset. And she's sitting here telling you that she had to deal with an estate lawyer. Here's March 27th, again, that's sent to the wrong email address she made, to her from Mr. Raymond. As I informed you before, this is just Sweetapple is representing the party plaintiffs in this matter, and all responses should come from his office.
Right.
This idea that because there's a state claim that's mentioned in a bankruptcy, that somehow now she can go go behind my back, go to the bankruptcy court, get Mrs. Patty to find another lawyer, Mr. Weinstein. She's very familiar with all these other lawyers that they're trying to bring in, and no communication with me by anybody. This is all being done to subvert a judgment that's worth 3 times what they're settling for. And her settlement, which she told you in court under oath, they're identical. The March settlement was for $375,000. When they go see Mrs. Sahm, it's now $225,000.
Okay.
Okay.
I don't understand what legal objection is. I hear...
Well, it's hard in this context.
I know it's hard in this context. For Ms. Garcia's already testified. For whatever reason, she's decided that she'd like to testify again. She's a member of the bar. She's got plenty of experience. This is how she chooses to proceed. This is how she chooses to proceed. And we'll take it as it comes. But I can't have you interrupting her testimony with your argument why her testimony is wrong. You'll get a chance to cross-examine her when she's done testifying.
Well, when she tells the story, and it's always got hearsay that Mr. Raymond did this, then instead of me saying it's hearsay, please stop, I'm now showing you the hearsay she's telling you. What she's just telling you is not true. Okay, and it's not. And so I'll refrain myself.
It not being true is not a legal objection.
True, and I'm trying. I'll just interrupt her in the middle of her story when she starts saying, "This was my mental impression based on what A, B, and C told me."
Or you could just wait till your cross-examination.
I could do that.
And let her testify in the form of a narrative.
Let all the hearsay come in and do it later.
Whatever you want to do, but what you can't do is interrupt her and argue your side of the story while she's testifying.
But
either object with a legal objection or don't and cross-examine her.
In all deference of the court, as awkward as it is, I have never had a time where a court has refused my request to make a witness who is pro se or a lawyer ask the question of themselves and answer it. There's no way I have any idea what she's going to say, what she's responding to, how I should object, and there's nothing I can do either interrupt her or correct her. because this is not the way you take evidence. So
I have never, and with all due deference to you, I have never had a witness say, please state your name. My name is John Parnofiello. And what do you do? I've never seen that before.
After background, I've done it all the time. Because
I've never seen it.
Otherwise I can't do my job.
Okay. I've ruled. Go ahead, Ms.
Okay, so
I'll just wait till she's finished.
I'm not telling you what to do. You either say objection, state your legal basis, 3 words or less, I will rule, or you can wait till the end and you can cross it down.
Understood.
So after negotiations failed in March, that settlement agreement was not entered into. A bankruptcy was filed by Mr. Bernstein individually. Now, Mr. Bernstein filed in evidence Exhibit 18, Defense Exhibit 18, is clearly a suggestion of bankruptcy filed by Mr. Bernstein pro se. That suggestion of bankruptcy was delivered to the court personally by Mr. Bernstein and Ms. Bernstein, and they went to the clerk, and the clerk canceled the sale based on that suggestion of bankruptcy. At the bankruptcy hearing that resulted in that order, which I will be contesting, they decided to use a strategy of saying that my suggestion of bankruptcy was a fraud, but my suggestion of bankruptcy was not used.
I don't understand. If you wanted to refer to all of these hearings, why didn't you all just provide me with the transcripts of these hearings?
I did move into evidence all the transcripts from the I filed it, Your Honor, for the last hearing.
This has been pending for I don't know how long, and this I will agree with Mr. Sweetapple. This is one of the most awkward ways of taking testimony or evidence. And if you're going to just tell me what happened in different hearings that you were a part of, isn't the record the best evidence? Couldn't you just provide me the record and let me know what was said in the different hearings? As far as why they did these things, you're just speculating as to that. That's not something I can consider as evidence. That's your legal argument. I'm really, really not sure what we're doing here with respect to the motion, but I want to give you your due process. So
what I'm explaining to the court is that, again, they go into court to file a motion to lift a stay, again, for a party that they've now admitted does not have any rights under a power of attorney.
Sustained.
Okay. The bankruptcy hearing speaks for itself as far as the order when you see the orders entered in the name of the estate. So you can consider that to see that that's now a party that has no legal rights based on everything that's been testified to in this court. The suggestion of bankruptcy that they're claiming that I filed that was fraudulently and entered an order that I was not a party and never saw this order until months and months later is not true. And there's an evidence that the suggestion of bankruptcy that canceled the sale was done by Mr. Bernstein, not me. Mine was filed as a courtesy. It contained one sentence that had no intentions or no misrepresentations, in my opinion. But they're trying to use that fraud here to infer that we did other nefarious things when it comes to the settlement. That's why it's important and relevant. Because there's been numerous times, and that will be in the 1.540 that deal with the transcripts from the guardianship and the mental health case, which I did provide to the court. I filed it all in court, and I asked them if they would stipulate to it, but they didn't. But I will deal with that in the 1.540, so you'll see why it's so frustrating to me that there's orders entered that I firmly believe as an attorney are not appropriate.
I'm objecting.
It's not relevant.
Okay.
Sustained. The objection is sustained.
So what happens then, Your Honor, during the bankruptcy, the daughter, JOANNA Sahm, files within 3 days of finding out that Mr. Morgenstein was hired to settle the case, files a guardianship to be appointed. but she wasn't appointed in the end. Charlie Rivard was appointed by agreement by Amber Patwell in June.
I'm going to check.
It's in the court file. It's been stipulated to, Your Honor.
It is. So I'm not really sure why you're testifying to it.
Okay, so what happened then, Your Honor, I didn't deal with Mr. Sweetapple directly because my understanding was he was terminated when, first of all, when Twig came in, then there was a bankruptcy pending, and then Mr. Sweetapple himself filed a notice in court that he has an evidence on April 18th that basically he doesn't have any more jurisdiction, that there's a pending guardianship. So basically there, he's admitting that there's nothing he can do here. His hands are tied. So at that point, in May, Ms. Patwell is retained on May 1st. Ms. Patwell is approved by the court through the stipulations and substitutions that are all in evidence. So
That's what we have advised.
Ms. Patwell's retainer that's in evidence also states very specifically she was retained for the foreclosure case. So it was represented to me that we would attempt to resolve the foreclosure case through the guardianship case with the approval of Judge Burton. Because when a contract is then entered into after reports, which of course we'll get into the contestations and those, but prior to the adjudication, those contracts are presumed valid. And I firmly believed that we had a good basis to do it and that Ms. Sahm was actually competent enough to enter into the contract. She had an attorney's advice. The attorney reviewed it. The settlement was given to Ms. Patwell in early May, I think May 5th or May 8th. She had till May 22nd.
Evidence.
My testimony. I'm the one that gave it to her.
Where's the document?
You gave Ms. Sahm?
No, Ms. Patwell. On behalf of, after she was hired by Ms. Sahm, her retainer retained her for the foreclosure and for the guardianship and mental health case. So she's officially her attorney.
Is that in evidence?
Yes, it's in evidence. It's in the retainer, and the retainer says specifically for foreclosure.
She's testified for this law. Where's the document where she transferred the settlement or anything to this happened?
It's in evidence, Your Honor, as exhibit. Let's see. 26, defense 26 is the retainer. Defense 25 is the stipulation for substitution in the guardianship case with Laura to Patwell.
Defense exhibit number 26.
26 is Ms. Patwell's retainer.
Yes.
Testimony was that she transmitted the settlement agreement to Ms. Patwell on the 8th of May, and there's no writings between Ms. transmitting any settlement agreement ever, and she's admitted that. And she says they were all hacked from her computer.
I don't know if I'm supposed to respond, but.
So I object to her statement. Best evidence of any transmission of the settlement agreement May 8th would be a scanned document, an email, some writing. Ms. Patwell was on the West Coast of Florida.
It was transmitted.
I'm just reviewing exhibit number 26.
The settlement agreement was transmitted to Ms. Patwell. I have text messages which I had produced, and from my point of view, it's when I'm talking to her. Are you hired? Yes. You know, here's a settlement. Go over it with your client. Whatever you decide.
Best evidence would be the text message that shows that she scanned a settlement agreement with Ms. Patwell.
So are you withdrawing your objection to the hearsay of the text messages?
No, not as to Ms. Patwell, as to her. She says she sent in a text message the settlement agreement to Ms. Patwell. I'm trying to show that there's no transmission of the stuff. And first I heard it's May 8th, now it's in a text message. Show me where, please, best evidence would be, where and when is this settlement agreement sent to Ms. Patwell?
Do you have
an
email, or is it through your text messages that you?
No, I transmitted through an email, Your Honor, but my email that I was using at the time lost over 1 million emails. I've been constantly hacked, and I've had to transfer vendors. I've not been able to recover those. Ms. Patwell moved from one email to another. She couldn't recover it. but I have text messages with her and her acknowledgement that she showed it to her client, talked to her client independent. And I also have here proof, just Your Honor, so you know, that at one point I'm working with the FBI and with investigators and private investigators to determine the source of the people who keep showing up to my house and the source of the hacking. At one point I received an email that's described as Kevin Hall, but when you look at the real address, it says John Raymond at NelsonMullins.com via Gmail at some gibberish. So I've given this to the investigators to try to figure out where my emails are going, who's erasing them, who's erasing my calendars. But it was transmitted to her. She obviously had it, and she agreed in writing to, on May 22nd, after going over it with her client numerous times, independent.
Move to strike, best evidence.
With respect to the best evidence rule objection, the best evidence rule only applies if there is a writing. She's testified that there is not, because she's been hacked and she lost her emails, and Ms. Patwell has lost her email. I'm overruling your objection. Go ahead.
So what happened during that time frame, Your Honor, from May 5th to May 22nd, basically Ms. Patwell had the settlement that I basically took the one I had done with Mr. Raymond and updated it to change it to the right parties, which I realized at that point was not the estate, and otherwise based on what I learned, and changed it to include protections and for release of funds. And also, the clients had determined the price at $225.
Had you had any communication with Ms. Patwell prior to Ms. Sahm signing the engagement?
No, I never even heard of her. Just like I never even heard of Mr. Weinstein. I had nothing to do with the representation. In fact, I refused to talk to Ms. Sahm or do anything throughout the bankruptcy or anything without her having a lawyer. There was no way that I was going to talk to her or have any communication directly with anyone without her having a lawyer that would look at it. And I told those lawyers in writing and in the phone many a times, this is your client, you do what you want. If it's not acceptable, let me know. If you want to make changes, make your changes. I had zero to do with the approval of it on that side. What happened come May 22nd, when it was executed, the clients came to my house. They signed it at my house. Then with Ms. Patwell's knowledge and permission, which is also in my emails, she allowed me to send my clients to the house to sign it because it had already been negotiated and finalized. And then my understanding is she also got on the phone with the client again and made sure, and the client signed it. So once that happened, Ms. Patwell and I immediately informed the guardianship court, because she was the guardianship attorney, and she also had the retainer for this case. But because Mr. Sweetapple apparently did not receive the DocuSign for the stipulation, which is an evidence, or sign it.
All speculation.
He testified that he did not receive the stipulation. So I'm saying maybe he didn't. I don't know.
He hasn't testified.
Okay. So the bottom line is that the stipulation was never entered into. So at that point, Amber Patwell realized, well, let me go ahead and file my appearance in a foreclosure case now, because I've been retained to represent her in the foreclosure case also. So the case was settled, and at that point, I firmly believe that when they filed the guardianship, the timing of it was during the bankruptcy when I disclosed to the court that the case was being settled with another lawyer. This guardianship happened. So the settlement had already been pretty much communicated and agreed to as far as the concepts prior to the bankruptcy being dismissed and prior to the guardianship being filed. But because of the delays in Ms. Sahm being able to have her attorneys, with Mr. Morgenstein leaving and then Amber coming in and then them filing the guardianship and her stipulating in with Laura and everything he had to do, and the timing, it took a few weeks to get it finalized and to get it executed. So that settlement was executed in good faith. And it was settled in not only my client's favor, but significantly in Ms. Sahm's favor. Because if you look at the risks and you look at the rewards of a settlement, and Judge Burton, and the transcripts are there, I don't know if you'll stipulate to the transcripts, but I'd love to have you have all the transcripts. I'll move them to evidence today. If you'll take judicial notice, they've been filed in a court file for months. I had ordered all the transcripts and analyzed them to determine for the guardianship case and the mental health case. So Judge Burton started looking into the settlement because there were allegations made immediately over there, including in the answer, I think in the responses, that the case is settled, Judge. We settled the foreclosure case, and we're contesting these 3 committee members. Okay, so at that point, the settlement's entered into. There's an objection pending on the committee. After the settlement was entered into, Ms. Patwell and her client obviously made the decision to agree to do a limited guardianship because
speculation. The document speaks for itself.
Sustained.
So the guardianship was entered into by agreement in June 27th, to bring in Charlie Rivard. Mr. Judge Burton held numerous hearings and ordered Ms. Patwell to turn over all of her notes, which was one of the documents I was trying to move into evidence that the judge didn't take in because it was hearsay, was everything that Ms. Patwell turned over to the court, all of her notes and notations, and he read into the transcripts and basically told us all at the hearing when Ms. Sahm was saying the house is worth $850 and I want, we can make money selling the house. And he's explaining to her in foreclosures how it works and how you can have appeal after appeal and bankruptcy to bankruptcy. You guys need to settle, or not settle, but talk about what you want to do. And then he decided to throw it out of his court and he threw it back to the foreclosure court, said, go handle it over there, I'm done.
Okay. Whatever happened in that action would be in the transcript of that action. Whatever Judge Burton said to explain is not hearsay because it's not off to the matter asserted, it's the effect on the listener. But be that as it may, it doesn't really matter. It has no moment to what we're doing here.
Right. So I firmly believe Ms. Patwell believed this was in everybody's best interest to resolve this case. The money was sitting in the court registry ready to pay. And instead, here we sit a year and a half later. It took them over a year, I believe, to file the motion to set aside the settlement. I had tried to get the funds released literally within days, and I was blocked by the attorney in the Bernstein in the Shirley Bernstein Trust to release the funds. So basically, this settlement was entered into voluntarily with the advice of counsel.
Objection. Legal conclusion.
Sustained.
Destroy.
Sustained.
So, speaking of the reports, Judge, there's 3 reports, and one of the people obviously testified today.
Objection. This is argument. There's no personal.
I don't know what she's about to say. I need to hear what she says before I.
We reviewed the reports specifically back at the time when they were brought in, and then there was an independent report after the fact by Dr. Sugar, which was relied on without saying what was happening. That I felt comfortable after looking at the reports, looking at the law, looking at the misrepresentations, looking at the 119 requests I had put out, that today, even when I saw the testimony about the MOCA test and malcognitive and testimony that didn't happen, and we felt comfortable that because one of the reports as an evidence said that Ms. Sahm can enter into contracts with her attorney, and that's in evidence, Amber and I felt comfortable that we were doing the right thing and disclosed it to the guardianship court immediately. So there was no finding of incapacity at the time.
Is there any document that indicates?
Yes, Your Honor. Can I mark as exhibit and the transcripts that have been previously filed and have you take judicial notice? I can tell you.
I've never seen them open.
you have been, it's been filed in court and you were served with them, sir. I can tell you the docket entry numbers and we're taking judicial notice of the entire file.
Tell us when we got transcripts.
Hold on. I'll tell you right now. Let me log in.
Let's get her list.
And I have a copy, but I've already provided
And I
the
just want
copies
to
to
make
the service.
I want to make sure that, Your Honor, something that was said is accurate and noted. But I believe Ms. Garcia testified that she settled this case before the guardianship was filed. Foreclosure case. It was settled before the guardianship was filed, is what she testified.
Are you asking me
I
that?
just want to make sure Ms. Garcia is not correcting that testimony, but that's what she testified to.
The settlement was obviously signed on May 22nd after the advice of counsel on May 1st. But the concept between the parties and their discussions were, I think, began in January because they're family friends forever. And I have Ms. Bernstein to testify to that there were conversations had and there was a decision made already back then that they wanted to start to resolve it. And that's why in March I was trying to negotiate and we had a bankruptcy and then
Okay.
2 attorneys later.
I'm not seeing any transcripts in the court file.
The transcripts were filed DE 264 through 275. I believe that's the transcripts. I filed them immediately after the last hearing. Let me see. Yeah.
.265 is a 22-page long transcript.
No, in 263, I filed a notice of filing for all purposes, the transcripts. Let's see. So I think
It's a notice of filing, but there's nothing attached.
Well, because it was large, so I think 265 is the first is one of the transcripts. It was a transcript in front of Judge Ferreira in the guardianship case from April 23rd, 2024.
Right.
And that's one. Then the next one is 266. And that was the proceeding in the guardianship case on May 13th, 2024.
Right.
The next one was 267, which is the transcript from September 5th, 2023, in front of Charles Burton in the guardianship case. Burton was the attorney before...
The judge before Judge Fewer.
Right. Then 268 is the transcripts in the guardianship case where Ms. Patwell was present on October 17th, 2023. Then 269.
I have no objection to transcripts from the May proceeding.
Okay. So then you want me to take judicial notice of docket entries 263 through 274?
Fine. Yeah, just the May. I don't have a problem.
275.
I've not read them or seen them, but I mean, we have orders. If the court wants to look at what Judge Burton was saying.
As opposed to having you all tell me what
Right.
what you gleaned from the hearing.
275. So.
Okay. I will so judicially notice those filings.
Okay, so 274 is not a transcript, Your Honor. Would this be composite 27?
Well, if you're going to mark it for evidence purposes,
Yes.
then the clerk is going to need a physical copy. If you want me to take judicial notice of the court filing, I could do that, and then on appeal, it will be transferred to the fourth without it having to be marked as a separate exhibit. So that's probably easier for Madam Clerk and for Trees.
Or mark these, Your Honor?
Now, if you have them, you can.
from the May and June proceedings.
All of the proceedings.
We're object to this being a composite. She's saying from all the proceedings. I don't think we're here to retry bankruptcy proceedings, a trust case proceedings, whatever else is.
This is just the guardianship and the mental health cases.
And they're filed in the court file, right?
Yes,
Do you want to enter them into evidence, or do you want me to just judicially notice it and access it from the court file?
if it's the same effect and admitted into evidence as Exhibit 27, I'm okay.
Then if you want them, then I will receive them into evidence without objection as Exhibit number 27. The clerk will need a copy of it.
As to the
I think those are the ones that were in the court file. That's all that she's asked me to
I have
judicially
no
notice.
problem with entering into evidence. We take judicial notice from the docket, so you don't have that paper. overwhelming.
It's okay.
No, Your Honor, it's 8 different transcripts. It started May 23, 2023. Because they're entered into evidence, for instance, Your Honor, August 14, 2023, injunction,
That's
saying that there were findings made. If you look at the transcript on August 14, 2023, the judge specifically made no findings. It was an agreed extension, 30 days with no findings. And they entered an order making findings, and they want you to rely on that. It's not true.
Your Honor, you
So
can't.
that transcript is clear as day.
Right, the transcript is going to be the best evidence of what happened at the hearing, which is why I'm saying I don't understand why at 4:30 we're just now realizing that perhaps we should have given the judge the transcripts of the things that we've been discussing.
And Your Honor, she's attempting to collaterally attack these orders, having them appealed to the final, and saying, oh, at this hearing, that wasn't said, so therefore it's not an order.
I don't take it as a collateral attack. And if that's what I'm being asked to do, I'm not going to do that. So I'm receiving those transcripts into evidence as Defendant's Exhibit number 28, which are purportedly the transcripts of the 8 different court hearings that we're here for the purpose of what transpired at those court hearings. So since we've disposed of the need of discussing what happened at those court hearings, understanding that Mr. Sweetapple is going to need to have a chance to cross-examine you, what additional testimony do you have?
Basically, my testimony is that this agreement that is being attacked was entered into with proper legal advice, with 2 attorneys of record.
Legal conclusion.
You are giving me a legal conclusion.
I believe, Your Honor, that we did nothing inappropriate, nothing nefarious, nothing conspiratorial, nothing improper when it came to entering into a settlement agreement with an attorney who was the attorney hired by Mrs. Sahm, accepted by the Guardian Court, and filed a notice in this case. When there's co-counsel, assuming that Mr. Sweetapple was still even the attorney after being terminated, I had no obligation to speak to him at that point. So,
To move to strike, was there any evidence I was terminated?
Overrule the objection.
so basically, Your Honor, once Mr. Sweetapple filed that notice on April 18th about the guardianship case, he knew that he had no authority to act. So just because you're the attorney of record does not mean you have authority to act. According to the bar rules, in fact, it says you can't even discuss the facts with opposing counsel. You can't do anything when it comes to the case without court authority.
Again, you're giving me a legal conclusion.
my opinion at the time.
Which is not you can't opine on what the law is, no matter how experienced you are.
Okay.
I get it, but you can't.
I understand.
It's a decision for me to make.
I understand. So based on my understanding, I negotiated with the right person, which was Ms. Sahm. And Mr. Sweetapple was not reappointed to the case or authorized until recently again when the guardian substituted back in. And in the meanwhile, for over a year, nothing had been filed to set it aside. And I just firmly believe that the allegations that are against my clients and myself are just not clear and convincing evidence of us doing anything that constitutes undue influence or fraud.
All right. Do you have cross-examination?
You concluded?
Ms. Garcia, are you done on your direct?
Yes, Your Honor.
Ms. Garcia, you've told me under oath you have tremendous experience in United States foreclosure.
I have experience, yes, sir.
And you told me it was obvious to you that this note was a joint asset, and that when Mr. Sahm died, Mrs. Sahm had the right to proceed to collect the note.
I don't recall telling that to you in those terms. What I do recall is being told that no substitution was necessary because the estate had no rights.
And you understood that from the first time you looked at this file?
No.
You looked at this note and his foreclosure case, and you believe that a joint note between husband and wife became an estate asset when Mr. Sahm died. You didn't know that it was clearly a survivorship wrong. And you didn't testify in your deposition with him.
I can say this much. Because of the filings in the federal court conflicted with the filings in the state court, and then I'm told by the estate attorney to negotiate there, I firmly believe that there was a gray area on what rights does the estate really have. They're telling two federal bankruptcy courts that they are the owners, they are the creditor. So I don't know who to believe when all the attorneys are lying to me and confusing and misrepresenting the different situations. Now, you, Mr. Sweetapple, did not, my understanding is you brought in Mr. Schreiber to do the bankruptcy case, but you didn't make any filings or representations there. Your position has always been constant and consistent that you can file for the dead man, but it didn't go to the estate. The other attorneys were consistent with the estate is the one who has it, and it's under a power of attorney under pre-need guardianship. Therefore, your client wasn't competent for years, according to the confusion that was given to me. So it's very hard when you have numerous attorneys in different courts and different representations made to different judges for whatever benefits you. When I'm trying to figure out, begging you guys in emails, who has rights? Who do I go to? Who signs a settlement? What do I do? And that's in evidence. My questions.
I have it right here.
I was told different things by different attorneys at different times, depending on what fit their needs.
I have your emails right here. I'm going to put them into evidence shortly. But you knew well before your client filed this bankruptcy that this was an asset owned by Mrs. Sahm individually, based on your experience, and you've admitted that in your deposition, haven't you? Please don't go off on a tangent. Just tell us whether or not you have admitted that you knew from the outset that this was a joint asset and that it belonged to Mrs. Sahm after her husband died.
I don't believe that that was my knowledge at all times. I believe that it fluctuated based on the representations made to the courts and the filings made by the courts, which caused confusion. Because when you have an estate saying it's ours and we are the creditor and filing for sanctions and filing also for dead people, but then it was a typo and they corrected it. I get confused when I have 5 different lawyers telling me 5 different things. That's why everybody was included in this settlement. Every court was referred to. Every case was referred to. Every attorney was referred to. So,
other than Mr. Sweetapple.
So
You saw that Mr. Schreiber appeared for Mrs. Sahm individually and for the estate, right, in the bankruptcy?
Yes, through a pre-need guardianship, according to the testimony of JOANNA Sahm.
And I'm going to show you emails, including here. Will you have a copy for this? I can approach Judge. What do you speak of email? And your
okay. What? I'm recording.
On March 24th, you're writing, to be clear, please clarify the following as soon as possible so I know what to represent to the foreclosure judge and the estate judge in my motion to cancel sale I'm filing Monday. Is it true the estate has no rights to the note and foreclosure case and only Patricia Sahm Sr. is the beneficial owner? So you believe that was the case, right?
I asked for clarification because that's not what they filed in the federal court. They said that they had rights. So I'm asking for clarification from the estate attorney of what to tell the court on March 24th.
Then you're asking him. Mr. Sweetapple represents Patricia Sahm Sr. through Joanne Sahm based only on that power of attorney. Why would you be asking him the basis for my representation rather than calling me to find out when I undertook to represent Mrs. Sahm individually and how I was operating with regard to a power of attorney? Why are you asking him the scope of my representation and how I got it?
I found out about this power of attorney the first time in the bankruptcy court when JOANNA Sahm testified to the pre-need guardianship that she supposedly hired Mr. Schreiber in the federal court. So therefore, I was
went into effect on Mr. Sam's death, and I represent Mr. and Mrs. Sahm for 2 years before he died, right?
I can finish answering.
Did you ever focus on the fact that I can represent a live husband and wife, and when the husband dies, continue to represent the wife, and there can also be a power of attorney, and that they're not mutually exclusive? So why are you asking Mr. Raymond about my representation and making these assumptions? You've testified last time we were here, and you keep testifying. I've been substituted. I've been terminated. I have no rights. I can be ignored. So why are you asking anybody other than me what my rights are?
On the same day, on March 25th, 5:05 p.m., when I wrote that email asking, I said I need clarification of these 6 questions so I could determine who would go into settlement. I asked about, is JOANNA Sahm the trustee? Is she the PR? If she's not a party to the foreclosure and she's not a guardian? Is it true that her only involvement in the foreclosure is solely based on power of attorney? But then I sent you an email that same day, by the way, in this chain at 7:49, and I asked you, I'm requesting that you agree to cancel the sale and do an immediate mediation with the plaintiffs. Please let me know your client's position so I can inform it to court my motion. So because you guys were bouncing me around so much and filing different ownership rights and different representations, I had to ask you guys the question to find out who needs to be in any settlement. That's what that was about. Me asking you guys to please tell me the truth once and for all of who do I need to include in the settlement.
Ms. Garcia, I have a pleadings address. We're both counsel of record, and you're sending emails to an address that I have never used on any document ever. And you complain that I don't respond to you. There is no Sweetapple at Sweetapple, Sweetapple.com, whatever it is. Sweetapple at Sweetapple.com, SweetAppleLaw.com, and pleadings. So
And then on March 27th, let's keep going through this, where you continuously email me at a non-existent address, even though we're both in the same pleadings file. And you get this answer on the 27th. As I informed you before, this is just Sweetapple is representing the party plaintiffs in this matter. And all responses should come from his office.
And at that point, I also then wrote to you and Mr. Raymond, and Mr. Raymond copied you, by the way, that address on March 30th at 422. He copied you.
At the same address you used. At the same address you used. That is not my pleadings address or my address.
I wouldn't know that. If he's responding to you at that address in an email chain with me, I'm going to assume he has the right address. And I do believe there's another email that's in evidence now that I will look for, that I sent it to that address and you did respond. So you have responded at that address before.
No, I've never responded to that address. I never got any of these emails, but you were repeatedly told that you would have to communicate with me. And at this time, you knew that I had filed shortly after this the fact that I contacted my client. She's had no recollection of signing a revocation of a power of attorney. And I became concerned and filed with the court a notice that the client indicated she had no knowledge of signing a revocation, that she wanted me to continue with the case. But I also let the court know that I was concerned about her mental capacity and that a guardianship had been instituted. So you knew I was telling the world that her competency was at issue, right?
You did file once you were told by your client, JOANNA Sahm, who you had been working through a power of attorney only, not with the mother. You told her, or she testified that she had met with you and Mr. Mullins or Mr. Raymond, and y'all had to try to decide what to do. And I guess y'all decided to file a guardianship.
I didn't decide.
On April 17th.
You all. I didn't decide to file a guardianship. I was told there was a guardianship filed.
Okay.
And I put you on notice and the world on notice.
Is this cross-examination, or
Yes.
are you all just arguing with each other about this string of emails that I can read?
Yeah. No, but I'm not in emails now. I'm talking about my filing with the court.
Can we move on, please?
Okay, yes. The order determining limited incapacity. Judge Burton said, this court, having reviewed the file, having considered the reports of the examining committee, and being fully advised on the premises finds based on clear and convincing evidence presented, one, the ward suffers from incapacity of the following nature and scope: unspecified dementia, impaired memory, and then lists the lack of capacity to contract, sue and defend lawsuits, etc. You know that this order that was entered by the judge was based on May 5th reports, and you were representing the Bernsteins during this proceeding, right?
On June 27th, I believe it is, it's your exhibit 13, or no, 3. This order was entered into after the settlement was completed by the same attorney who entered into the settlement. And this order to determine limited capacity was entered by agreement, not by me, because nobody approached me. I would have definitely contested it because I had been ready to fight the insanity of these reports that were so legally
insufficient. You were
insufficient.
counsel of record in this case, and you never filed an appeal of this order. You represented your clients in this proceeding in the guardianship court. They had counsel, you. And your clients were involved from day one and knew about these guardianship examinations, didn't they?
This order was entered into by agreement of Miss Patwell. And
where does it say the court's doing it based on agreement?
Do you see copies?
I've seen the communicate.
You're served. You're served with this.
I was emailed during this time frame. I remember after the fact when y'all were going back and forth between Eileen O'Malley, who was Joanna's attorney, because Joanna applied to be the guardian, and the court was not inclined to allow Joanna or Patricia Jr. to be guardians because there was a fight among the two daughters. Because the estate documents stated that Charlie Rivard would be the successor trustee, Ms. Patwell determined at that point, okay, the foreclosure case is done. Now I have to deal with my client in the incapacity case. At that point, because the foreclosure case was already done, the settlement had been signed, she'd filed objections to the reports. At that point, the agreement was made without me agreeing. I think Kevin Hall accidentally agreed because he was led to believe that everybody agreed, from my understanding. But y'all entered into this order, and when I mean y'all, I don't mean you, Mr. Sweetapple, because you had nothing to do with this case. Eileen O'Malley and Amber Patwell. So Joanna and her mother's attorney, Ms. Patwell, agreed to allow Charlie to have some limited rights moving forward, not retroactively. And by the way, no motion was ever filed in that case to set aside the settlement, which is where the court then, had they gone to this judge, Judge Burton at the time, and said, Judge, we got a problem. We want to set it aside. Judge Burton started listening to it, and you'll see in the transcripts, he started saying, okay, a privilege is waived, accusations started flying quick, and you'll see what he said in the transcript. But this order was entered voluntarily.
From the very beginning.
My clients did not do much in this guardianship at all. Originally, my original client, which was the Bernsteins, we filed a notice of interest because they were making allegations against us in the settlement in the guardianship case. And I believe there's testimony that the whole reason the guardianship case was even filed was to stop the settlement. It was purposely timed and done solely to stop the settlement, in my opinion.
And this order determining limited incapacity that you were served a copy of has never been appealed or taken.
There's been many, I don't know how you call it, rumblings or filings that deal with the fact that this violated Ms. Sahm's rights to due process because there was no hearing held and there was no actual determination made by the judge. It was done by an agreement.
Who filed?
I'd have to look at the file, but I do recall reading different pleadings and allegations in this case. I mean, listen, I think Ms. Patwell did a wonderful job for her client. I completely disagreed with entering into an order of capacity when you had so many good defenses. But that doesn't make an attorney bad or good if we disagree. I'm telling you this, that I did not agree to this limited incapacity order. I firmly believed at the time we did the settlement agreement that they would win this issue. But after the fact, it was determined to be settled in June 27th because it wouldn't have had an effect on the settlement because the settlement was done. This was moving forward. So my client, the Bernsteins, were out. There was nothing for them to do. We were done, over. I thought we were gone. The money was in the registry, ready to go on May 23rd. And then all of a sudden, all these nefarious allegations come out about me and Ms. Patwell in our actions.
And so, do you have any order? This was an order determining limited by Judge Burton. Is there any order or opinion in any way vacating this?
There's filings that...
Is there any order or opinion vacating this? Yes or no, please, and let me explain.
There is no order vacating this, no.
And the judge says he relied on the May 5th guardianship examinations, doesn't he?
I don't know.
Doesn't he say that right in the preamble?
He says that he reviewed the files, he considered the reports.
And you were a
he was informed
of record. You were a counsel of record for your clients in this proceeding, correct?
Yes
or no?
Yes, and it also says he was informed of the agreement of Patricia Sahm, and it says, and all interested parties. But I never agreed to this, because as usual, orders keep getting submitted to the courts without my agreement or my knowledge, or that are inconsistent with the file. And the only reason that I haven't fought all these orders to date is because my client hasn't paid me in 2 years and has no money.
So you got this
When
order?
I get money, I will address all these issues, sir, because I'm tired of these representations being made that aren't true.
So you got this order on June 27, 23, a year and a half ago. It was mailed to you. You think it's erroneous, and you've not attacked it because you haven't been paid. But when you get paid, you're going to attack it.
Well, now that the ongoing...
Your testimony?
My testimony is I have not attacked it yet because I can't afford to, as a sole practitioner. My client can't afford to pay me when his funds are held up. And the fact that we're still ongoing and using these orders knowing that they're not true, it's an ongoing fraud that I will deal with now that it's timely again.
And when did you move to enforce the settlement agreement that was allegedly entered on May 22nd, 2023? When did you file a motion to enforce it?
I did not file a motion to enforce it because we were dealing with this in the guardianship case, I think through June, July, August, and Judge Burton was having hearings on it and doing discovery and disclosures. And Ms. Patwell and I decided, let's just wait and let the guardianship court or whoever rule on it, because the allegations from day one have been about our nefarious conduct. And at that point, her and I both took a pause and said, you know what? We feel like we did the right thing, but there's allegations out there. Let a court determine what they believe.
Isn't the settlement agreement captioned in the foreclosure case number?
Yep, Prince 12.
Defendant 6.
Don't you mention that there's a foreclosure case and the case number is listed on the bottom of the first page?
Well, I can say this. This document,
answer yes or no.
the document speaks for itself. However, it's not captioned in the foreclosure case. It's captioned settlement agreement. And it says that the interested parties are Bernstein Family Realty, the Bernstein family members, Patricia Sahm, and now at that point, after being told she's the sole owner and surviving spouse of Walter Sahm, and for good and valuable consideration, we acknowledge we entered into the settlement agreement. And this settlement agreement deals with all the cases. It cites the Marion County case. It cites the foreclosure case.
Tell me where it cites the probate case that you say you're litigating. Where is the probate case?
Under the first page, sir, the second paragraph on the recitals, it says on June 24, 2021, was an order admitting a will to probate and appointing personal representative JOANNA Sahm.
That's not the
that was entered into for Walter Sahm in Marion County, case 21 E002332X.
And then it says Patricia A. Sahm has full authority to resolve the mortgage and note foreclosure matter. Okay. There's no mention of anything about a guardianship in this document, is there? No case number involving the guardianship, right?
I'd have to look through it.
Take a look.
Now, let me see. At this point in time, this was May 22. There was no guardian appointed yet. So this was May 22, 2023. So there would be no guardian to mention, but
and you were dealing
with
Ms. Patwell, and you decided to settle this. She agreed on the 22nd of May, you testified. That's when you agreed to settle it, right? May 22nd.
That's when the settlement was actually signed. The agreement between the clients had been much earlier on, maybe as early as January, February, March, where they had their communications and agreements. However, there was the bankruptcies, and then there was her having to hire an attorneys, and then the guardianship case was filed. So there were numerous delays that were outside of my control.
And here's your testimony on page 69 at line 5. And then basically we said, okay, we agree. On the 22nd, she said, we agree, let's get it done. I'll file my appearance. So she agrees with you on the 22nd of May, and that's when she files an appearance at 6:37 at night. Right? That's what you testified to. You and Amber agreed
on May 22nd to settle the case, and then she files her notice of appearance.
On the 22nd is when she had made her final decision with her client, independent of me or anyone else, after reviewing with her client. They had it, like I said, I think since the 5th or the 8th.
You were negotiating
She decided
with her for how long? For how long when she wasn't counsel of record? You knew I was counsel of record. You knew she wasn't counsel of record. How long were you negotiating with her before May 22nd?
I knew of Amber once she was retained, I assume about May 2nd, May 3rd, because the guardianship case had been filed and she was hired to do the foreclosure in her retainer and the guardianship.
And she appeared in the guardianship, but didn't appear in the foreclosure, right?
She did eventually file her notice of appearance, but she had been retained specifically for that case and represented at TV, so I relied on it.
She told you, I've been retained in the foreclosure, and you negotiated with her, and she hadn't appeared. So you know I'm counsel of record. You don't send me any proposed settlement agreement. You don't talk to me. You know I represent Mrs. Sahm. Well, you're dealing with Amber Patwell, who's told you she's been retained in a foreclosure but hasn't appeared in the case, right?
So she filed her notice, as you know, on the same day, the foreclosure case.
No, the evening. In the evening.
The same day.
Right. Your clients all went to Mrs. Sam's house. How many people did you send to Mrs. Sam's house with this settlement agreement to get signed the evening of May 22nd?
I didn't direct numerous people to go. I asked, Amber was out of town, Miss Patwell was out of town, and I said, the clients are at my house. It's in the text messages. I said, I can send them to the house to sign it. And she said, fine. So I can't tell you how many people went, but I could tell you that the case had been settled before they got there, so there was no undue influence or pressure on Miss Sahm that night. It had already been decided by both lawyers. We agreed to the logistics due to the location of the house and the location of Miss Patwell and the fact that nobody could afford couriers. So
how many of your clients left your house and drove to see 84-year-old Mrs. Sahm by herself in her house the evening of May 22nd?
I think the only people that were at my house that day were Eliot and maybe Miss Bernstein, because the boys signed it at their house. So they kind of made stops. So it started at my house, and with approval of Miss Patwell, it went like from my house, then it went to the three different boys' houses, and then it went to Miss Sam's house.
And this settlement agreement doesn't have any signature by counsel, right?
No.
And it doesn't have any date that the payment has to be made.
It does very specifically address, which we already covered on direct, the fact, and I can read it to you again if you'd like.
I don't know if there's a date. What date? We're now almost 2 years from the date this was allegedly signed. Approaching that. When is this money have to be paid by under this agreement?
It will be paid within however quick the clerk can cut a check once the judge makes a ruling that the settlement is binding.
Well,
if the settlement wasn't binding...
You haven't asked for that ruling. You haven't sued the guardian asking the guardian to sign anything. You just filed this in November of 23, attached to some other document, right? You've never asked the court to have Mrs. Sahm enforce this or Mr. Rivard, the guardian, to sign this. Right?
The agreement was provided immediately, and the next day, Mr. Rose had it in the Shirley Trust case, and I asked him if I could release the funds, and he said, don't release the funds. Let's see how it plays out in the guardianship. Ms. Patwell and I decided, because now they became an issue as far as complaining about the settlement, that we would let the guardianship court tell us where the money's to go. So I didn't know where to pay the money once it was signed, but the money has been sitting there, and it says very clearly on page 4 about the payment and how and when it'll be paid, and it says it would go to Ms. Patwell's trust account, the 225, but then it says that they're being held in the court registry for the benefit of the 3 young Bernstein boys. The parties agreed to cooperate at a hearing to be held to ensure the 225 are released directly to the trust of Ms. Patwell
What's the
as
date,
directed
ma'am?
by the court order.
What's the date? What's the outside date that this has to be performed by?
The
Is
only-
there any such date in the agreement?
The only reason it hasn't been paid yet is because you're contesting the validity, so
not
I
what I'm
can't
asking.
ethically release the funds to Ms. Patwell.
Not what I'm asking you. I'm asking
It's-
you, where's the material term in this agreement?
The material terms, there's 10 of them. If you look through the payment, it's very detailed. And it says exactly what's going to happen. It says the parties are going to cooperate for a hearing, but the parties didn't cooperate. Then it says the Bernstein shall pay the entire check directly issued from the clerk registry. And then it says if court orders are necessary, either in the Walter Sahm probate case in Marion County or the Palm Beach foreclosure case or in the Shirley Bernstein case, the parties agree to fully cooperate and file any needed joint agreed motions to confirm the settlement and to release the funds as agreed and to file a dismissal to foreclosure. No party or person can interfere with the agreement or cause any further delays in releasing the funds or cause the property to sell in foreclosure.
So what has
Now,
he
what
done?
happened is instead of cooperation, immediately in the guardianship, it got raised that they had a problem with the settlement. So because Ms. Atwell and I were involved in the guardianship case, we asked Judge Burton for direction. And then Judge Burton started holding hearings specifically about the settlement and the money and the release and everything else until finally he got frustrated, I believe, and threw it back at this court to determine if this court believes it's settled or not.
And so what did you do in this court to enforce?
This has been asked and answered so many times.
And the record's clear. The record's clear. I apologize.
Can we please move on? How much more
Yes.
cross-examination do you want?
Not many more.
Then please ask leading questions. I got it. There's no material, there's no date that it needs to be completed. There isn't a date in this, is there?
And there was
No.
never a motion before or after the agreement. And so your clients did sign the March settlement agreement indicating that Mrs. Sahm Sr. was incapacitated and agreeing to pay her $355,000, right?
Let me look at the agreement. What exhibit number was that? That was exhibit plaintiff.
You need to look at that.
Yes, I do need to look at this settlement because that settlement was never used. So you're asking me to comment about my thought process during another settlement that's not this settlement. So I need to look at that settlement before I make any comments, sir. I'd like to refresh my recollection.
You don't know that your client signed it and it was $355,000. You've already testified to that in the last 2 hours.
That was not the question. I believe you had added something to it. So
No, I asked you if your client signed that March settlement agreement that indicated that Mrs. Sahm was incapacitated and provided for payment of $350,000.
So I need to look at that part about the statement you're making so I can understand why it's there and testify to you what happened. Let's see.
It's a yes or no question. Did he sign it or not?
He did sign the retainer. I mean, he did sign the settlement agreement, but
Okay, next question.
Okay. And did you ever provide Ms. Patwell with that signed agreement where your clients had offered to pay $355,000 before you sent over a $250,000 settlement agreement in May?
no, but I told her about it. I told her exactly what was going on. And in fact, her and I had many discussions about the rewards and the risks of the settlements and of the guardianships and of the bankruptcy filings and of what was in the best interest of our clients. And then each of us consulted with our individual clients and determined that this was in their best interest to end this madness once and for all and let everybody move on.
All right, let me just, you know, if you give me one moment.
Sure.
I think I'm,
This email string has just been brought to me, but it's not in evidence. So
what's that? You want the emails?
it's not in evidence.
Yeah, I'll move that into evidence, Your Honor. That's with the notation that that's not my email address on those emails.
Do I have a copy of it? Is that
It was used during the first, I believe, 45 minutes of cross-examination.
Yeah, you have a copy.
You all read them back and forth to me.
Yeah, I moved it in as 14, I think.
will be received into evidence as plaintiff's exhibit number 14.
And as for the bankruptcy judge, the order granting NREM relief that's in evidence, when the court specifically found that you had filed the suggestion and that you were and that it was factually false and legally incorrect and was designed to mislead the state court or the clerk of the court. You haven't appealed that order either, have you?
No, but I do plan on it now that it's being used in the way it's being used.
Mm-hmm.
I do have an attorney ready to go in there because...
You don't think it's time barred, April 14, 2023, and we're now in January of 25?
Nope. Not according to my bankruptcy lawyer. It's a direct fraud on the court.
And who do you think committed a fraud on the bankruptcy court?
JOANNA Sahm and her attorney, Mr. Schreiberg, who took on that case with no retainer based on the purported power of attorney of JOANNA. Although at the same time you're claiming that she's incapacitated and can't enter the contracts or do anything, Mr. Schreiberg appeared in the court believing the power of attorney existed. Mm-hmm. So as an officer of the court, because I know his business partners, I told him at the hearing, Mr. Schreiberg, you may not be aware of this, but your client, JOANNA Sahm, does not have a power of attorney anymore. Therefore, you don't have a client, and the estate is not a client. And then I also explained to the court at that time that the suggestion of bankruptcy that was actually used to cancel sale was not my suggestion of bankruptcy. But Mr. Schreiberg went ahead and gave the order to the court.
So
we'll deal with it there.
Did you file any motions for sanctions against Mr. Schreiberg or anybody?
No, I don't like to go after other lawyers normally, especially ones I've known for years and years. But
and so you don't think Mr. Schreiberg represented JOANNA Sahm in the bankruptcy?
It's not relevant.
Pardon?
The question is not relevant. The question is not relevant.
All right. I have no more questions, Judge.
Okay. How many additional witnesses do you have, Ms. Garcia?
If I could have a 2-minute break, I might be done.
Sure.
If I could step outside?
Sure.
Thank you, Your Honor.
Hello. Yeah. 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 We totally got it out. I don't know what he got out of this whole fucking thing, but yeah. Can you ask Sweetapple any more questions about this? All right, yeah. Okay, love it. I'm just the patient, not the doctor.
Yeah. Keep it further.
Mind blowing.
Garcia, do you have any additional?
Defendants rests.
All right. Both the plaintiff and the defendant have rested.
Can I suggest, Your Honor, since you've been more than patient with us, that we submit written?
That was what I was going to suggest. How long would it take for you all to provide written closing arguments?
10 days, 2 weeks,
2 weeks.
2 weeks.
That way we can give you the memos.
you get the transcript.
But just so there's a date on it, what's 2 weeks? 2 weeks would be.
Today's the 20.
Does the 11th work for you all? I have 7 days being the 4th and 14 being the 11th. You want the 12th? Or you tell me.
What date? What days?
Uh, 14 days would be the 11th.
How about,
Could we do the 13th?
that's what I was going to suggest.
Because, yeah, I'm.
Okay. That's fine. You both agree to it. Could you just file the written closing arguments in the court file, but also provide a courtesy copy to Division AO to the CAD?
You don't need courtesy?
Not the e-courtesy, the scan it and email it to Chambers. Just make sure that the other side is copied on it so that everybody has it, because otherwise it takes a couple days before it's docketed before I'd be able to see it.
How about if we both do it at 5 o'clock on the 13th?
You could do that. However you want to do it. I'll keep my eye out for those, and then once I receive those, I will enter an order.
And then, Your Honor, if there's any, would you like us to provide copies of the cases also there, or statutes, or just cite them?
If there's something that's relevant and germane to your argument, you want me to review it, you could provide it to me like a briefing book.
Okay.
I have access to Westlaw, so I can look it up. But if it's something that's very important, you may want to provide me a copy as well.
Okay.
Okay.
Thank you for hearing us, Judge.
All right. Thank you all.
We do appreciate your time and your patience, Your Honor, and thank you.
Have a nice day.